the light of the above, we answer the question framed in favor of the workmen by holding that the decisions of the learned single judges in K. Karunar Supra and in P. Purnachandra Rao Supra and of the division bench in M. Venkateshwarlu lays down the correct law. Consequently, the decision of the division bench in B. Vidyasagar is overruled. The reference is answered accordingly.
Chocolate. Have a great sleep.
Yes.
I please, my lords.
Yes. Yes.
I beg to represent, my lords. My lords, all these three writ petitions, my lords, are of the same SSC.
Yes.
Petitioner is a firm engaged in execution of civil contracts, and what is under challenge are the 148 notices issued for reopening, my lords. My lords, the reason for issuance of the reopening notices, my lords, is the interim arbitral award ordered by this Honorable High Court, which was withdrawn by the petitioner, was sought to be taxed by the authorities. Plus, though there is slight variation in dates, my lords, sum and substance is the issue is now covered, my lords.
Okay.
In the case of the same SC only. Lords, there are various other issues in this ITTA order, lords, they have submitted.
Yes. Which is the relevant portion? Just take
Lords, Lordship may kindly turn to page 5, my lords.
Yes.
First paragraph. The controversy is in two parts, Lordship. Get what?
Yes.
The first is as to whether the amount deposited by a party to the award in compliance with the directions issued by the court in which the award is under challenge can be treated as the income of the other party, that is the SC, for the assessment year during which such deposit was made. That is the issue even for consideration in all these three matters, my lords.
Yes.
And the second, my lords, is the interest part, which is not under challenge.
Yes.
My lords, Lordship may kindly go to the last paragraph in the same page, my lords. When the deposits are made in compliance with the directions issued by the court during the pendency of the dispute, it is difficult to treat the amount so deposited as the exclusive property or income of any particular SC. Even where the permission is accorded for withdrawal of the same, it is always subject to the outcome of the proceedings before the courts. There exists every likelihood of a view being taken by the court contrary to the claim of the party who is permitted to receive the amount and he being required to refund it if the final outcome goes against him. When such is the uncertainty and contingent nature of the amounts, it is difficult to treat it as the income of the concerned SC. And Lordships have followed Supreme Court, my lords, and it is the case, very same SC, my lords. Case of the very same SC.
Here the awards are following arbitration or
Yes, my lords. Arbitral tribunal has held in my favor.
This is a part of the income, is it not?
My lords, what has happened is, my lords, arbitral tribunal has held in my favor. The government has filed an appeal before the Honorable High Court. Honorable High Court granted an interim award, directed the respondents to deposit 50% before the High Court, and I was permitted to withdraw the same. This was sought to be taxed by the authorities. What our Honorable High Court held is, it will be taxed only after the appeal is decided by the High Court.
In that assessment here, when the appeal is either
decided. Now what has happened in this present case, my lords, in 2014-15, the appeal is held in my favor. I have received the entire amount. I have also paid the taxes. I have the challans also with me, my lords.
okay, fine.
And that has become final. Both this appeal, the view taken by our court in this appeal, as well as the fact that I have paid the amounts in 2014-15 have become final now.
Yes, Mr. Prasad.
First one, in this case, not they are challenging 148 notice. But two of in the repetition, two of them are intimations and not they are intimations issued to the SSE. And in for one of the years, it is brought after regular assessment was paid. Of course, my learned friend has now filed this the DUT lordships. But they should otherwise normally go back to the assessing officer for assessment.
But now the issue is, and he has already paid the income tax in the concerned assessment year, where the order of the High Court, the
order of the High Court,
the appeal of the state was dismissed. Third, Mr. ABA. Yes.
This matter, the assessee paid
Can
the
you
tax.
use this? Yes.
In this matter, the assessee paid the tax in advance before filing the return. Then he filed a return with a delay of 6 months. Then he was found payable about 11 lakhs and odd tax, and he deposited already 12 lakhs. Then a notice has been issued that you have to pay interest on the late payment. And challenging that, he filed an appeal before the Commissioner of Income Tax Appeals. That appeal was allowed. Then the department went by way of appeal to the tribunal. Tribunal allowed the appeal, stating that the Commissioner of Income Tax has the appeal before the Commissioner of Income Tax not maintained. Then this writ petition has been filed. This is squarely covered by the judgment of the Supreme Court and we are permitted to pass out.
Yes. Yes.
Delay in filing furnishing return. Interest. Assessee furnished return after delay of 11 months. Tax paid before due date of filing return. Interest charged on the ground that tax paid could not be deducted from tax due on assessment. Interest not penalty. Interest payable in case where tax not deposited prior to the due date of filing return.
Yes. This is a very short order. Let us read the entire order.
Yes. This appeal has been preferred against the order of the High Court of Delhi in CWP number 1745/99 passed on December 21st, 2001. Respondent assessee earned substantial capital gains for the assessment year 95-96 for which return for the income tax return was due to be filed on October 31st, 1995. The return was filed on September 29, 1996. That is after a delay of 11 months. However, taxes due were paid on September 25th, 1995, that is before the due date for filing of the return. Though the return income was accepted on January 29, 1998, yet interest was charged under the provisions of 234A of the Income Tax Act 1961 on the ground that the tax paid on September 25, 1995 could not be reduced from the tax due on assessment. Being aggrieved, the assessee filed revision petition under section 264 of the Act on November 9, 1990 before the Administrative Commissioner requesting to delete the interest charge under 234A of the Act. The Administrative Commissioner, by the order dated, upheld the action of the assessing authority and dismissed the revision petition. Assessee being further aggrieved, filed a writ petition in the High Court of Delhi, which has been disposed of by the impugned order. The High Court, while accepting the writ petition and setting aside the interest charge under section 234A of the Act, has come to the conclusion that interest is not penalty and interest is levied by way of compensation to compensate the revenue in order to avoid it from being deprived of the payment of tax on the due date. The High Court also held that interest to be payable in the case where tax has not been deposited prior to the due date of filing of the income tax return. Revenue has challenged the aforesaid decision by filing special leave petition before this court, wherein leave was granted on 20th January 2003. Having heard counsels on both sides, we entirely agreed with the finding reported by the High Court, as also the interpretation of 234A of the Act as it stood at the relevant time. Since tax due has already been paid, which is not less than the tax payable on return income, which was accepted, the question of levy of interest does not arise. Thus, we find no merit in this appeal, the same is dismissed. Order of the High Court, which is under challenge, in CA number, is reported in Dr. Pranoy Roy versus Commissioner of Income Tax, 254 ITR 755.
Yes. Who appears for the other side?
It's covered, but
Heard Mr. R. Ranganathan.
May I please, my lordship?
Yes.
My lord, 6 to 11 relates to same issue, same petitioner, my lord.
Yes.
Tax period involved is different. My lord, issue is covered against me, but the interest and penalty also levied, my lord. To that extent, I have to argue.
Yes. What is the issue here?
Issue, my lord. Writ petition is filed questioning the vigors of Rule 89.5 of the CGST rules, my lord. Rule 89.5, my lord. Rule 89.5, my lord, it prescribes a formula for deriving input tax credit, my lord.
What is under challenge in this? Let us take one writ petition.
Yes, my lord.
The first one, item
May
number 6.
kindly take up 17434, my lord. Second writ petition.
Second case.
My lord, writ petition is filed questioning the vigors of amended Rule 89.5 of the CGST rules, my lord. My lord, actually, this rule, my lord, prescribes a formula, my lord. Actually, ITC, it is a claim of ITC on input services, my lord. Rule prescribes a formula 89.5. My lord, actually, section.
No, what is your prayer here to set aside? Order dated 12/9.
12/9/19, my lord.
Where, let us read the order.
It pays 62 to 68, my lord.
Yes. This is an order in original. This is a service tax.
This
No.
is under the GST, my lord.
Under the GST.
Yes, my lord.
Let us read this order. It's a short order. Let us read it.
Yes, my lord. Ceylon Laboratories Private Limited, so and so, are registered with the GST Central Tax Department with the GSTN number so and so. The SSC filed refund application online through RFT 01 on 15/5/2018 under the category of ITC accumulated due to inverted duty structure for an amount of rupees 71,37,380. CGST and SGST, and submitted refund application manually in this office on 26/7/18. On provisional verification of the refund application filed by the SSC in RFT 01A, 90% of the eligible amount, 94 lakhs 9,49,656 was sanctioned rupees 8,54,690 white sanction order number 85 of 18 provisional order dated 13/8/2018. Further, on detailed verification of the refund claim, remaining 10% of the refund claim of rupees 2,15,080 rupees was sanctioned by final order dated 12/9/18. My lord, I made an application for refund, and refund has been sanctioned as provisional order and also final order. However, on verification of the subject claim, it was found that the SSC has taken the credit of rupees 1 lakh 1
1
crore
crore.
40 million for the total period, my lord,
Okay.
for all the 6 petitions on inputs, and the credit of rupees 23 lakhs 44,630 on capital goods and rupees 18,30,450 on input services. As per the clarification issued by the board notification 26 of 18 Central Tax dated 13/6/18 with effect from 1st July 2017, in Rule 89, Sub-Rule 5, the following substituted, namely: 5. In the case of refund on account of inverted duty structure, refund of input tax credit shall be granted as per the following formula. Maximum refund amount is equal to turnover of inverted rated supply of goods and services into net ITC divided by adjusted total turnover minus tax payable on such inverted rated supply of goods and services. Explanation: for the purpose of this sub-rule, the expressions net ITC shall mean input tax credit availed on inputs during the relevant period other than the input tax credit availed for which refund is claimed under sub-rule 4A or 4B or both. My lord, earlier Rule 89.5 reads that net ITC, my lord, expression net ITC includes input on goods and input on services also, my lord. By this notification, input on services has been omitted. Input on services has been omitted, my lord. In view of the This is with
Kindly
retrospect.
read, then we'll come later.
In view of the above clarification issued by board, net ITC under Rule 89.5 for the purpose of granting refund under inverted duty structure is input tax credit availed on inputs during the relevant period. Accordingly, the eligible refund is as follows. Below, this is tabulation given. Adjusted total turnover, net ITC, inverted turnover.
Yes. Then, in view of the above,
In view of the above table, the maximum refund eligible is nil. However, on the refund application filed by the SSC in RFT 01A, the SSC mentioned net ITC as 1 crore 71 lakhs 17 lakhs 12,000 inclusive of inputs and input services and capital goods, and accordingly rupees 9,49,656 was sanctioned wide final order dated 12/9/18. Accordingly, a show cause notice was issued to the SSC wide reference number so and so dated 22/19 as to why the amount of rupees 9,49,656 erroneously refunded shall not be recovered along with applicable interest and penalty under section 73(1) of the CGST Act. Personal hearing. Accordingly, an opportunity for personal hearing was provided to the SC on 23/7/19. Mr. Sitaram Reddy, authorized representative of Mrs. Celan Laboratories Limited, attended personal hearing on 23/7/19 and filed written submissions dated nil to the show cause notice and reiterated the same at the time of personal hearing. Submissions of the SSC. SSC, by letter dated nil, submitted the following. They are the manufacturers of oncological formulations products, and they applied for refund of ITC accumulated due to inverted tax structure. The claims for ITC for the above months have been filed in the month of May 18, that is before the date of issue of notification number 26 of 18, central tax dated 13/6/18, having retrospective effect from 1/7/2017. Notification 26 of 18, central tax dated 13/6/18, stipulated that the refund of tax on capital goods and input services was not available. However, the department sanctioned the refund claims inclusive of tax on capital goods and input services. The total sanctioned CGST of rupees 75,96,778 was credited to their account. Out of the above sanctioned and credited amount, an amount of rupees 66,05,406 pertains to ITC on capital goods and input services. They submitted that rupees 75,96,778, which is SGST portion, that was sanctioned but not credited till date. Out of the above, an amount of rupees 1,32,10,812 pertain to ITC on capital goods and input services demanded from them. They reversed rupees 949,656 by debit entry dated 28/2/19 in their electronic credit ledger, but has not paid the applicable interest at 24% under section 53 of the CGST Act 2017, and penalty equivalent to 10% of tax or 10,000 rupees, whichever is higher, under section 73(9) of the CGST Act 2017. Regarding payment of interest on CGST part, they are ready to pay interest but not SGST, which was sanctioned but not credited to them. With regard to penalty demanded, it is not sustainable as there is no suppression on their part. Discussions and finding. I have carefully gone through the show cause notice reply submitted by the SSC and oral submissions during the course of personal hearing. In the instant case, the issue is to be decided on whether SSC is eligible for refund of input services availed on account of inverted duty structure or not. If so, whether refund granted to the SSC on SENVAT credit taken on input services arising out of inverted duty structure is liable for recovery or not. In the instant case, the SSC is exporter of bulk drugs and claiming ITC of input services and capital goods, and the same gets accumulated due to inverted duty structure. Accordingly, the SSC is filing refund of accumulated credit of input services and capital goods on account of inverted duty structure. In this regard, it would be prudent to refer Rule 89.5 of the CGST Rules 2017 dealing with refund of accumulated ITC on account of inverted duty structure. In the case of refund on account of inverted duty structure, refund of input tax credit shall be granted as per the following formula. Maximum refund amount is equal to turnover of inverted rated supply of goods and services into net ITC divided by adjusted total turnover, tax payable on such inverted gated supply of goods and services. Explanation: for the purpose of this rule, the expressions net ITC and adjusted total turnover shall have the same meanings as assigned to them in sub-rule 4. Milord, earlier it is sub-rule 4 says, Milord, input tax credit on input goods and input services. As per rule 4, net ITC means input tax credit availed on inputs and input services during the relevant period. However, by notification 26 of 18 central tax dated 13/6/18, it was clarified that with effect from 1st July 2017, in Rule 89 for Rule 5, the following shall be substituted, namely 5. In the case of refund on account of inverted duty structure, refund of input tax credit shall be granted as per the following formula. Maximum refund amount is equal to turnover of inverted rated supply of goods and services into net ITC divided by adjusted total turnover minus tax payable on such inverted rated supply of goods and services. Explanation: for the purpose of this rule, the expressions net ITC shall mean input tax credit availed on inputs during the relevant period. Below, earlier it was net ITC means, below, input tax credit availed on inputs and input services. When by notification 26 of 18, it has been retrospectively omitted, and the net ITC defines only input tax credit availed on inputs during the relevant period, other than input tax credit availed for which refund is claimed under sub-rules 4A or 4B or both. In view of the above clarification issued, net ITC under Rule 89(5) for the purpose of granting refund under inverted duty structure is input tax credit availed on inputs during the relevant period. Accordingly, in the instant case, the eligible refund is calculated as. In view of the above table, the maximum refund eligible is nil. However, in the refund application by the SSC in refund 01A, the SSC mentioned net ITC as 1,71 lakhs 23,953 inclusive inputs, input services and capital goods, and accordingly the refund of 9,49,656. This 9 lakhs relates to input services, my lord, was sanctioned by final order number 85/2018 dated 12/9/2018. Therefore, the difference amount is rupees 9,49,656 was granted to them erroneously, and the same is liable for recovery. SSC reversed 9,49,656 by debit entry number so and so dated 28/2/2019 in their electronic credit ledger, and the same is liable for appropriation. Since the refund is erroneously sanctioned to the SSC, the same is recoverable along with interest under Section 53 of the CGST Act. With regard to penalty, SSC submitted that no penalty is impossible as there are no suppression of facts. In the instant case, there are no suppression of facts. However, there was an option available with the taxpayer under Section 73(8) of the CGST Act 2017, wherein if taxpayer pays tax along with interest under Section 50 within 30 days of issuance of notice, no penalty is payable. The taxpayer failed to utilize the same. Therefore, as per Section 73(9) of the CGST Act, the SSC is liable to pay penalty at the rate of 10% of tax or rupees 10,000, whichever is higher. Accordingly, I find that the SSC is liable for penalty under Section 73(9) of the CGST Act 2017. Accordingly, DRC 07 in the prescribed pro forma is enclosed here with this order. I confirm order for recovery of 9,49,656 being refund irregularly granted under Section 73(9) of the CGST Act. I appropriate an amount of rupees 9,49,656 reversed by the SSC by debit entry number so and so dated 28/2/2019 in their electronic credit ledger towards the demand mentioned at 1 above. I confirm the demand of interest on the amounts mentioned at 1 above at applicable rates under Section 50 of the CGST Act. I impose penalty of rupees 94,966 being 10% of the duty demanded under Section 73(9) of the CGST Act.
Now this is covered by this refund of
this is covered by the In my reply affidavit, I have filed judgment of the Honorable Apex Court, my lord.
Union of India versus VKC
Yes,
Footsteps.
my lord. In VKC Footsteps Private Limited.
Relevant portion, let us see.
9 to 65, my lord.
Para.
The judgment is enclosed, starts from page 9, my lord.
We have an independent copy.
I have filed along with the reply affidavit, my lord.
Give the reply affidavit. Yes.
My lord, before that, my submission is initially I have reversed it from whatever the amount sanctioned to
But
me.
this is an appealable order.
But I have questioned the vigors of Rule 89.5, my lord.
Yes.
It is covered against me, my lord, covered against me by Honorable Supreme Court
That's
judgment.
what. Please take us to that portion, and thereafter we'll see your claim as to interest and
My lord,
penalty.
my submission is first initially I have reversed through in electronic credit ledger, my lord. Later on they stated that I have to pay in cash. I have paid it to the extent of input tax credit. I have paid it. Your lordships will get it that at.
That's fine. It's okay. Let us
I
see
have filed along with the reply affidavit. The order also I have filed, my lord.
Yes.
At page 8. Your lordships may kindly see page 8. My lord, out of refund, my lord, eligible.
See, we are not the appellate authority, is it not? We are not the appellate.
Well,
We had
Lordship,
entertained the writ because you had made us challenge. Basically, it was against this order in original. Just to avail the writ jurisdiction, invoke the writ jurisdiction, you had made a challenge.
Batch
We are
of
not now that challenge. We are not going to go into all these things.
rule,
As an appellate authority, we will not go into this.
page 9, my lord. Page
The
9.
judgment starts.
The judgment starts at page 9, my lord.
Yes.
At page 54, my lord.
Yes.
Rule 89.5 has been Rule 89.5 paragraph 82.
Para.
82, my lord.
Yes.
Rule
Yes.
80. May I read, my lord?
Yes.
Rule 89.5 of the CGST rules provides for the computation of the refund of ITC on account of an inverted duty structure. The rule as it was originally enacted provided for a refund of ITC paid both on input goods and input services. Rule 89.5 was amended on 18th April 2018 with the prospective effect. On 13 June 18, Rule 89.5 as amended was substituted with retrospective effect from 1st July 2017. The effect of this amendment is that refund of unutilized ITC can only be availed on input goods. Section 164 of the CGST Act empowers the government, being defined in Section 253, to make rules for carrying out the provisions of the Act on the recommendations of the GST Council. Subsection 3 of Section 164 stipulates that the power to make rules shall include the power to make rules with retrospective effect not earlier than the date on which the provisions of the Act came into force. As a result of the amendment of Rule 89.5,
Please come to, this is under challenge, is it not? G.1,
Yes.
next slide. Validity of Rule 89.5 of the CGST rules in exercise of the rule making power under Section 164 of the CGST Act. That was the discussion.
yes, my lord.
Let us come to the conclusion.
Conclusion is at page 64, my lord. Paragraph 111, my lord, 111. The above judicial precedents indicate that the field of taxation, this court has only intervened to read down or interpret a formula if the formula leads to absurd results or is unworkable. In the present case, however, the formula is not ambiguous in nature of unworkable, nor is it opposed to the intent of the legislature in granting limited refund on accumulation of unutilized ITC. It is merely the case that the practical effect of the formula might result in certain inequities. The reading down of the formula as proposed by Mr. Natarajan and Mr. Sridharan by prescribing an order of utilization would take this court down the path of recrafting the formula and walk into the shoes of the executive or the legislature, which is impermissible. Accordingly, we shall refrain from replacing the wisdom of the legislature or its delegate with our own in such a case. However, given the anomalies pointed out by the SSE, we strongly urge the GST Council to reconsider the formula and take a policy decision regarding the same. Having devoted our attention to the submission at the bar, we have come to the conclusion that the judgment of the Madras High Court needs to be affirmed by dismissing the appeals challenging that verdict, while the appeals against the judgment of Gujarat High Court by the Union of India should be allowed. The division bench of the Gujarat High Court, having extracted the provisions of section 54.3 and rule 89.5, held that the latter was ultra vires. In its decision, VKC Footsteps India Private Limited, the Gujarat High Court held that by prescribing a formula in sub-rule 5 of Rule 89 of the CGST rules to execute refund of unutilized ITC accumulated on account of input services, the delegate of the legislature had acted contrary to the provisions of subsection 3 of section 54 of the CGST Act, which provides for claim of refund of any unutilized ITC. The Gujarat High Court noted the definition of ITC in section 262 and held that Rule 89.5, by restricting the refund only to input goods, had acted ultra vires section 54.3. The division bench of the Madras High Court, on the other hand, while delivering its judgment in Trans-Ternary Story, Afghan's joint venture Supra, declined to follow the view of the Gujarat High Court, noting that the proviso to section 54.3 and more significantly its implications do not appear to have been taken into consideration in VKC Footsteps India Limited, except for a brief reference. Having considered this batch of appeals and for the reasons which have been adduced in this judgment, we affirm the view of the Madras High Court and disapprove the view of the Gujarat High Court. We accordingly order and direct that the appeals filed by the Union of India against the judgment of Gujarat High Court dated 4th July 2020 in VKC Footsteps India Private Limited and connected cases are allowed.
Fine. So therefore, validity of this rule was upheld by the Supreme Court. Now, the consequences of this recovery is that interest is automatic under 50 subsection 3.
Below section
But insofar as penalty is concerned, yes, you have a point in view of this. So there was no suppression or mistreatment like that.
Yes, my
This
lord.
are also been accepted.
Yes, my lord.
So
In respect
therefore-
of... Yes, sorry, my lord.
Therefore, we may set aside the levy of penalty, imposition of penalty, while dismissing your challenge to Rule 89.5.
In respect of interest also, my small submission is that below section...
Let us see CGST Act, section 50, subsection 3. Section 50.
Section 53, my lord.
Yes.
My lord, section 53 earlier, when they proposed, my lord, by the time of proposal, my lord, section 53 has not been amended. Earlier it was, your lordships may kindly see in footnote 53, now it is by Finance Act 2022, it has been amended, and in that it is added that where the input tax credit has been wrongly availed and utilized. That I am covered by that. But earlier, my lord, Your Lordships may kindly see 53, a taxable person who makes an undue or excess claim of input tax credit under subsection 10 of section 42, footnote, my lord, at the footnote.
Yes.
Or undue or excess reduction in output tax liability under subsection 10 of section 43 shall pay interest on such undue or excess claim on such undue or excess reduction as the case may be, at such rate not exceeding 24% as may be notified by the government on the recommendation of the council. My lord, earlier it is erroneous refund has not been in.
They themselves are. Yes. Yes.
Lord, in my reply affidavit, I have relied on some case laws, my lord. For interest, I have relied on, my lord, case in the Indian Carbon case, my lord, at page 77 to 81, my lord.
Page
77 to 81.
India Carbon.
Indian Carbon, my lord. Where it says, my lord, there is no substantive provision for levy 70. Page 77 to 81.
Yeah.
75 is the operative portion, my lord, paragraph 29.
75.
Yes, my lord. Page 75.
Page 75. Starts at 77.
My enclosures to annexures to my reply affidavit, my lord.
Ah, yes. India Carbon versus State of Assam. Page
Yes, my
77.
lord.
Yes.
It's
Paragraph
paragraph 29, my lord.
29.
I'm sorry, my lord.
There is no paragraph 29.
I'm sorry. Indian Carbon case 77. Paragraph 29. I'm sorry, my lord. 77 to 81.
Okay. Ms. Suma, you need not go into. What we intend to do is, insofar as your challenge to this 89.5 is concerned, that is answered by the Supreme Court goes.
Yes, my lord.
So therefore, recovery of this amount stands.
Yes,
This
my lord.
this part of the order, we uphold this order. Insofar as levy of interest and imposition of penalty is concerned, we remand it back to the original authority to hear you afresh and then pass an appropriate order, keeping in mind the observation made by the authority himself as well as subsection 3 of section 50.
Yes.
What do you say? Yes.
made dispute. I request your lordships to look at the writ petition, writ affidavit, my lord.
Read.
Writ petition.
Ah.
Your lordships will find the impugned order from pages 23, my lord. As I submitted earlier, my lord, petitioner is a society, my lord. It has been denied input tax credit of 58 lakhs on the ground. The returns have been, revised returns have been filed beyond 6 months, and the input tax credit earned by the petitioner has lapsed.
Page.
Page 23, my lord, the impugned order.
Kindly read.
Gist of the assessment proceedings. Gist of the facts of the case of the assessment proceedings. Input tax is disallowed from April 2005 to August 2007 on revised returns 59 lakhs 80,669. This, my lord, on page 24, my lord, the concluding paragraph, as per AP VAT rules 26A, he is citing, he has committed a mistake, my lord. It should be read as 23, rule 6, sub rule A, clause A, my lord.
Page.
Rule 20, page 24, my lord.
Yes.
As per AP VAT rules 20, it should read as 23, my lord, 23, 6A. The time limit for filing the VAT forms 213 is within 6 months from the end of relevant tax period. As such, the claim of ITC from April 2005 to August 2007 claimed in revised returns is proposed to be disallowed. However, the ITC claimed in original VAT 200 returns for April 2005 is acceptable. So, revised returns on the ground that they have been filed beyond 6 months. The first respondent has said that input tax credit of 59 lakhs earned by the society has lapsed. For the proposal, my lord, we submitted a detailed reply which he has extracted from pages 5 to 11, my lord.
Ultimately, what is the order?
Ultimately, my lord, on page 35.
Kindly read that portion.
Please, my lord. Operative portion, my lord. The claim of revised input tax credit for the tax periods April 2005 to August 2007 by way of,
Where you are reading?
in the operative portion, in the calculation portion, my lord. The assessment proceedings for the tax period April 2005 to December 2008 are passed as follows.
Yes.
Serial number 1, my lord. The claim of revised input tax credit for the tax periods from April 2005 to August 2007 by way of filing of revised form VAT 213 on 27/2/2008 is rejected.
Yes.
So the first respondent, my lord, he is relying on clause A, sub rule 6 of rule 23 to deny me the input tax credit which I had earned of rupees 59 lakhs 80,000 and odd, my lord. This has been challenged in this writ petition on the ground. Rule 23, sub rule 6 of rule 23 is ultra vires the parent enactment. My respectful submission before your lordships will be to endeavor to show that it is creating a right or abrogation of a right or essential legislative functions which consists in, my lord, essential legislative function, as your lordships are aware, it consists in laying down the various aspects of the policy and framing them as binding rules of conduct. So, creating a right for ITC and abrogating the right for ITC are primary and essential legislative functions which the parent enactment has not delegated to the state government. My lord, VAT as a system, my lord, was introduced in the year 2005 and it was a countrywide reform, my lord. I request your lordships to now look at the cases book which I have filed, my lord, where at the time of introduction of VAT, the Value Added Tax Act came into force from 1/4/2005. The Act, the statement of objects and reasons I have enclosed, my lord, page 162. The cases book, my lord, the spiral bound book which I have given.
How long will you take? This will take some time.
45 minutes.
This will take time. Mr. Raji Reddy. Your reply, how long will it take?
Lord, my length is because, but I won't take more than 10-15 minutes, Lord.
I will also try to complete it with as early as possible
Otherwise,
because
no,
I have
it
in the
will
note
some other
submitted,
time, Lord.
I have come out with cross-referencing also, which will be very
Otherwise,
easy
we'll
for
have
your
it-
lordships.
Otherwise, we'll have it after Sankranti.
Yes.
Milord, as you like, Milord, but
Because it's a
I can
challenging
reduce it to
balance.
half an hour also, Milord.
No, that's the, we don't want you to cut short your submission. We'll have it on a Wednesday only, hearing day, after the Sankranti.
Sankranti.
weekday, no? Please. Same, one batch. Yes, yes. Yes.
Lord, in these appeals, Lord, filed by the revenue, Lord, there are 5 appeals. 6 appeals, Lord.
Five.
199.
Present batch is 5. Yes.
There are 6 blood appeals. Blood item 14, 199 of 2000.
You want to take up that?
No, no. There are totally 6 appeals that are involved.
It's all right.
Small convenience set compilation.
Okay.
Your lordships are sets out the questions of law.
Okay.
Just
Blood, in the compilation that has been submitted by
Yes.
respondent, blood, if your lordship will find that there are 4 years which are cited here, that is 4 ITTAs, 199, 183, 307 and 92.
Yes.
But in the next page, they have given the substantial positions of law in respect of the assessment years. But the first substantial question of law is on the facts and circumstances case where the SC did not satisfy the conditions under section 36(1)(7) read with section 36(2) of the Income Tax Act with regard to his claim of bad debts, whether the finding of the tribunal dismissing the appeal preferred by the revenue and upholding the claim of SC.
One minute, Mr. Prasad. Yes. Yes.
in toto is sustainable in law. And with the failure of the tribunal to note that CBDT circular dated 6/5/78 relied on by the SC with regard to its claim of deduction of bad debts, since cannot supplant to the statutory requirements under section 32 of the Act. Its finding relying on the said circular are sustainable in law. Then when the SC is not doing banking business and bad debts claimed by it were not shown as income in the profit and loss account, and it did not comply with other conditions of the 3617, read with 36(2) of the Income Tax Act, it is entitled to claim the same as deduction as erroneously held by the ITAT is sustained. So, not first three questions not revolve around the same issue of bad debts, whether not they can claim these bad debts under section 36(1)(7) not without satisfying the conditions therein. Then not in respect of 1 year, that is 1999-2000, that is ITTA 92 of 2006, there is an additional issue of royalty. Royalty, not expenditure claimed as not expenditure, royalty commission paid as a expenditure, but that was allowed by the tribunal. Then the other, one more additional issue in respect of assessment year. 98, 99 and 99, 2000. Not as far as royalty is concerned, not where finding of tribunal upholding claim of SC with regard to royalty payments without considering reasons of the authority sustainable in law. Then with respect to commission on cancelled checks, which arises in 2 assessment years, finding of the tribunal upholding the claim of SC with regard to commission on removed checks without appreciating concurrent reasons. So therefore, not insofar as these 4 appeals are concerned, if your lordship sees 96, 95, 96, 97, 98, these involve only bad debts. However, as I see from what they have also submitted, not the tax effect is not, it's below the monetary limit. Probably those 2 have to be dismissed on that account.
Which one?
Withdrawn, not that, on account of
Which one?
19, yes, Brian. But ITTA 199 of 2005
Yes.
and ITTA 183 of 2005.
13 and 14.
Yes, Lord. 13 and 14.
We'll dispose it. First, let us dispose it of that
Yes.
item numbers. Separate orders, 13 and 14.
documents before the tribunal will be ITA 199 of 2005 for 95-96 and 183 of 2005.
Yes, yes.
ITA note.
Yes, yes. Just check up. Huh? Just check. Sure. Yes, now 15, 16, 17.
The order is common respect of all the assessment years. Right? Only 4 years. That's all. May I just request your lordships to take up number for the ITPA 307.
Yes, 307.
Zero 07 is against which ITTA? ITA 307.
Let us see the order of the tribunal.
Yes, Lord. 98, 99. Blood order of the tribunal 307. This is a common order for, in respect of all the years. But insofar as 98, 99 is concerned, Lord, it's a SSC's appeal. Because several issues were there before the tribunal. Because I had prepared note in this, the other case where it's being dispensed, no tax effect.
Mr. Ishwar, it appears he may need some time.
Assist your lordship. Paragraph 6.6 of the tribunal's order that deals with allowability of patent.
That is the only issue here.
No, but there are three issues.
See, this paper, which is the compilation we should see, the blue one,
That is the
page here.
so that is a convenience compilation.
Okay.
Your lordship will take the appeal.
Okay, appeal for.
There the common order of the tribunal is filed.
Yes.
In that paragraph 6.6 of the order of the tribunal deals with the patents.
May I read the order, Blood?
Yes.
6.6. We have carefully considered the rival submissions.
Just 1 minute. Let us find out.
At page 41, Blood, because there are several appeals. I prepared it, one of them, and we are taking up
41.
the other one. Page 41.
Yes.
We have carefully considered rival submissions. The claim for bad debts is made only in cases where price subscribers are reported in payment. The first aspect that is as stated before is whether the claim for deduction as bad debt is allowable under section 36(1)(7). Second aspect of consideration is the point of time at which such deduction is allowable. The alternative claim of the SSE is to allow this expenditure loss under section 28 or under section 37 of the Act. We first examine the allowability of the claim as bad debt. Honorable Andhra Pradesh High Court in the case of Govardhan Udayan versus so held as follows. Relationship between price subscriber and foreman is of a debtor creditor when the price subscriber receives the amount and undertakes to pay the subsequent installments due to the aforementioned. A full discussion on this issue is page 671. So, wherein the judgment of the Madras High Court in the case of Amangal versus Shekhar Narayanan, 1989, Madras 53 was referred to. In its judgment in the case of Sriram Chit Funds and Investments versus Union of India, Honorable Supreme Court considered the constitutional validity of an enactment and had no occasion to consider relationship which arises between foreman and price subscriber. In note 6.62, whatever may be the interpretation placed by courts on this issue, CBDT placed its interpretation on the issue. The instruction is issued by CBDT, so dated 16 May 1978, reads as under: A. If any person organizes chit funds and for this purpose brings the members together, administers the chit funds and thereby earns commission, etc., profits made by such person is income from business, and if for any special reason there is loss, then it is business loss. Normally, there should be no loss to the organizer unless he takes over the liability of some of the members. In such a case, the unrecovered amount due from such members will have to be treated as bad debts. That's what the CBT also stated. Then note coming to para 6.65. The binding nature of the circular issued by the Board of Direct Taxes on the Revenue Appeal needs to be reiterated. As the Central Board of Direct Taxes raised its interpretation on the issue, the same has to be necessarily applied for all the income tax authorities to also on. Then they refer to Supreme Court judgment in the case of Dinan Chemicals about the binding nature of the circulars. Then in Azadi Bajao Andolan, again, not as referring to binding nature. Thus, then the 6.67, thus the revenue has to apply the interpretation laid out by the CBDT on this issue in the circular. Thus, we hold that revenue is bound to take a view. Amount recoverable from a defaulting price subscriber by a foreman is a debt. But we are not on this issue at all, this present appeal. Then coming to page 45, para 6.69. This is the main issue. Coming to the second issue, we find that there is a change in the system of claiming of deduction of bad debts by the SSC. Earlier, SC was making claim for bad debts in respect of defaulting price subscribers at the close of the check. In the later years, the SC is claiming deduction in the year of default itself. What is to be seen is whether the SC has taken a honest and bona fide decision, and whether the decision to write off is dictated by the reality and in the light of the event till the time the decision is taken. During the assessment proceedings, the SC has filed details of the bad debts claimed, showing a number of tickets against which suits have been filed till 31/3/1995, as well as suits filed in the financial year 1995-96, as also 96-97. These details have been examined by the assessing officer as evident from page 3 of the assessment order for 95-96. We do not know whether such details have been filed for the subsequent years or not. Then coming to the position of law, subsequent to the amendment of section 36(1)(7), with effect from 1/4/1989, the same is enunciated by the decision of this tribunal in the case of ITO versus Anil H. Rastogi, 86 ITD 193 Mumbai, as well as the decision of the Chennai bench of the tribunal in New Deal Finance and Investment 74 ITD 4469. In the case of Anil Rastogi, the Mumbai bench of the tribunal held as under: before the amendment by Finance Act 1987, with effect from 1/4/89, section 36(1)(7), the words used were any debt or part thereof which is established to have become a bad debt in the previous year. Established to have become a bad debt in the previous year. The words any bad debt or part thereof, which is written off as irrevocable in the accounts of the SSC for the previous year, have been inserted by the amendment. Therefore, not earlier it had to be established by the SSC, and now what the amended provision says is SC needs to only write off. That is how it is understood by the tribunal. It is clear from the substitution itself that the intention of the legislature was to leave it to the prudence of the businessman to judge himself as to whether a particular debt has become irrecoverable or not. Previously, the words used were any debt or part thereof which is established to have become bad. It was significant in the sense that it was obligatory for the SC to prove or show with demonstration that such a debt had become bad. But taking away the words which is established to have become bad, the intention of the legislature is clear that it did not want to burden the SSC to prove that the debt has become bad. It is left to the prudence and judgment of the businessman to consider it as a bad and irrecoverable debt and write off the same in his books of account. If he writes it off as irrecoverable in his accounts in the previous year, it is sufficient compliance of the provisions to claim the deduction under clause 7 of subsection 1 of section 36. The onus is of course on the SC to show that he has written off the debt which is permissible under the amended provisions. Under these circumstances, it is not obligatory for the SSC to place demonstrative proof for establishing a debt as bad if he has taken steps to write it off in the previous year, left to his prudence, and it is sufficient compliance of claiming debt as bad debt under 3617. The accountant member had thus rightly allowed the deduction under 3617 to the S. Honorable Gujarat High Court in the case of so-and-so 256 ITR 772, wherein it is held as follows, that under the provisions of 3617 of the Act, deduction has to be allowed in computing the income referred to in 28 of the Act of the amount of any bad debt or part thereof, which is written off as irrecoverable in the accounts of the SC for the previous year, subject to the provisions of subsection 2. Prior to the amendment from April 1, 1989, allowance under this clause was confined to the debts and loans which had become irrecoverable in the accounting year. Thus, under the provisions of 3617 as in force from April 1, 1989, all that the SC has to show was that the bad debt as written off as irrecoverable, as the genuineness of such a claim by the SC was not in doubt. Therefore, no question of law arose for reference. This being the sole High Court decision on this issue, we respectfully follow the same. But this was the position as at the time the tribunal passed it on, and hold that in the post-amendment scenario, a write-off in the books of account of a bad debt is sufficient, and the assessing officer has no option of deciding the year in which the debt has become bad. If a debt is not allowed as bad debt in the year of write-off, then it can never be allowed as subclause 3 and 4 of the section 36(2) has been done away with effect from 1/4/1988. Thus, we prefer to follow the order of the Mumbai bench on the position of law after amendment to section 3617 read with 36(2) C4 with effect from 1/4/89. Then 6.6911. This being the law, we now revert to the facts of this case. Assessment years 95, 96, 97, 98. Claims for bad debt have been allowed by the First Appellate Authority. Revenue is in appeal. But these are the appeals which your lordships have now on the ground of low tax effect. We do find no infirmity. In the orders of the Commissioner of Income Tax for the assessment years, as the court suggests, the SC has given details of claim and the assessing officer has examined the same. These are voluntary payment in discharge of legal obligation. SC would be entitled to have the amount deducted as bad debt in the year of write-off. Decision whether the bad debt has become bad or not has to be viewed with a dispassionate attitude, and the fact that the SC has not taken steps by way of legal proceedings against the debtor would not automatically justify that he was not entitled to write off the amount as bad debt. Bombay High Court in 188 ITR page 1 held as follows. In our view, when two facts are proved, namely the debt is straight and it has become bad, court should not interfere with the decision of the SC in writing of the amount in a particular year, unless there is anything patently wrong with the SC's decision. In all these cases, the honesty of the judgment is relevant. What is required to be shown is that, having regard to the facts of this case, a bona fide assessment has been made by him to that effect that the realization of the debt is not possible. department cannot insist on demonstrative and infallible proof that the debt has become bad. In these 2 assessment years, chit groups have closed and some of the price subscribers who have taken funds have defaulted and this he could not recover. Then coming to, because these 2 have now been dismissed by your lordships, not on the ground of low tax effect. Coming to para 6.16. Now we consider the appeals of the SSE for the assessment year 98, 99, 99, 2000 on the same issue. The crucial difference in the claim of the SC for these 2 years is that the SC was either making the claim for such bad debts in respect of price subscribers on the close of the chit, that is the year in which the chit is closed. From the assessment year 1988-89, SC made its claim after default was made by the price subscriber in payment of 4 installments, so stage at which it was claimed. Though we have held that the decision of the SC to write off a particular sticky debt cannot be questioned by the revenue, when it is a honest decision, and though we have given a finding that the decision is a honest decision viewed from a businessman's point of view, we observe that there is another angle to this issue. The claim proceeds on the premise that the money lifted by the price subscriber at an auction is out of the funds flowed in due to the legal requirements as the foreman. This premise is not true. The chit contributions of the other subscribers are handed over to the price subscriber on an auction after the foreman deducts the commission. The funds of the foreman are involved only to the extent of defaults both by the priced and non-priced subscribers. The claim of the foreman to the extent his funds are involved can be considered as an allowable claim. A future liability that may arise to the foreman due to the continuing default in paying installments by a price subscriber cannot be claimed at this point of time. This factor can best be explained by the following example. In a chit, there are 24 subscribers, and each of them contributes 100 per month for 24 months, and to second month, but probably skip over this one. After the example, they refer to the accounting standards. Then with para 6.620, on these facts, a claim of loss without corresponding inflow of funds from the foreman, which is a definite possibility in this method of claim, cannot be upheld. The amount of loss can definitely be allowed to the extent that the foreman has put his funds and has come to a conclusion his funds are not recoverable due to the amount becomes sticky, and to the extent he has taken an honest decision for writing of the same in his books. In other words, bad debts can be allowed to the extent of the installments defaulted by the price subscriber and written off as bad debts in the books of this. For the future installments that are likely yet to be defaulted, no claim can be allowed. A SC officer cannot replace the judgment of the businessman. The facts that the SC has written off as bad debt when price subscribers defaulted for 4 consecutive months does not, to our mind, affect his claim, as this is based on past experience of the SSE in his business and is in tune with the current RBI norms for NBFCs as well as for banking companies. These decisions have become a prudential norm in the financial sector. Thus, there is nothing wrong in adopting this guideline or policy. Then finally, we have to mention that this issue has not come up during the course of arguments of the case. If the SC has made the claim as indicated above, no prejudice would be caused to him by setting aside the matter. Similarly, no prejudice caused to the revenue on this ground to examine the claim afresh. To allow the claim to the extent indicated above, fresh collection of facts and figures required, and thus we set aside the issue to the file of the SC, consider the claim afresh in the light of this order. Now, after having laid down the law as the tribunal understood, but it remains the SC officer to go on facts. But the crucial error here is whether mere claim of the SSC and his prudent business sense telling him these are irrecoverable irrecoverable and taking a decision to write off is sufficient or not is a simple question before your lordships. Not whether it's deduction allowable under section 36 and clause 7 of section 36, subsection 1, 7 of the Act. Not a mere the write-off is sufficient or not, or something more has to be done, whether the assessing officer has the power to go behind the claim or not. This is a simple issue. Not as on the date when these judgments were pronounced, I mean, these were taken up, probably there were not many cases. Not subsequently, the Supreme Court also has dealt with it in cases such as Southern Catholic Syrian Bank, or Southern, which one is it? Southern Technologies, TRF and other cases. And the latest case of the Supreme Court in Kathy Realtors is what I am relying upon. Now, Lord, if you, for a moment, if your lordship states the order of the assessing officer, because your lordships will have to see how the assessing officer has dealt with, well, disallowing the claim of bad debts. Assessment order. Here, 88, 89. 88, 89. '97, '98. But if we take ITTA 183, 183 is still 183 on the other below now. Below monetary item is the shown. Assessment order. '98, '99 note assessment order in ITTA 307 is at page 65.
60.
Page 65. But page 65, your lordships have got it, no? Yes. At page 66, bad debts. The SC debited an amount of 5,72,83,000 to P&L account towards bad debts. On verification of the details furnished by the SC, it is said that A, these bad debts represent arrears of subscription remaining period up to the unpaid by the successful check bidders after 4 months of default of payment of subscription. That is even before the termination of the check. This being followed in this year only. The prize money was advanced to the bidders against liquid security, immovable property, surety by others, etc. C. The SC has recourse to initiate legal proceedings against the defaulters in payment of subscription after lifting the check. Then, from the aforesaid observation, it is clear that considering various recourses that the SC has to initiate recovery proceedings, the period considered for recognition as bad debt is very short to determine the arrears as irrevocable or bad. Considering the fact that the SC, as per the Chit Fund Act, has a right to take legal action being a conductor of checks or so defaulting subscriptions, the moot point is whether any amount written off is allowable as a deduction or only bad debts written off is allowable. This interesting question was also in the said case, ITCL wrote off a sum of 2 pounds. The assessing officer held that ITCL had done any effort to, did not do any effort to realize the said amount from the above department. Since there was ray of hope, he didn't allow the same. In the above, the department submitted that even after amendment, SC had to satisfy that the amount was written off was irrecoverable. By the amendment to section 36(1)(7), no blank permission given to the SSE to write off any amount. Under the above circumstances, the tribunal held that as per law prior to amendment, the SC had to establish that any debt had become bad in the previous year itself. In the amended provision, the SC is entitled to claim deduction if any bad debt is written off as irrecoverable. one cannot ignore the inclusion of the word bad prior to debt. This prior condition for allowability for the deduction of under section 36(1)(7), even after the this is a prior condition for allowability of deduction under 36(1)(7), even after the amended provision. Once the debt is established to be bad, deduction will be allowed in the year in which the SC writes off the same. Besides, as per provisions of 36(1)(7), the amount of any bad debt or part thereof, which is written off as irrevocable in the account of the SC in the previous year, is allowable subject to the provisions of 36(2) of the Act. The provisions of subsection 2 of section 36 provides that no such deduction shall be allowed under such debt or part thereof, unless such debt or part thereof has been taken into account for computing the income of the SSE. The errors are there, Lord. For computing the income of the SSE of the previous year, in which the amount of such debt or part thereof is written off, or of an earlier previous year, or represents money lent in the ordinary course of business of banking or money lending, which is carried on by the SSE. Now, this is crucial here, crucial aspect, which the tribunal of course ignores. Tribunal says it is sufficient to write off. As a prudent businessman, if you have done it, you have done it. If you have written off in your books, that's good enough. But they don't go further. As discussed above, the SC is running the business of chits which cannot be construed as money lending business. The SC's business cannot also be construed as banking business prescribed in 36(2). SC shows income under the head 4 months commission, 4 months dividend. 4 months commission is received by the SC 5% of the value of the chit on account of conducting the chit. The amount subscribed to the chit by the subscriber has not been offered as income. Therefore, in view of the provisions of 36(1)(7), read with 36(2) of the Income Tax Act, the amount claimed as bad debt but not offered as income in any previous years, it cannot be allowed as a deduction. Moreover, a period of 1 day to 1 year is too short a period to initiate recovery proceedings and to declare a debt as bad and irrecoverable. Accordingly, 5 crores also is disallowed, added back to the income. That is how the assessing officer, not, my opinion, probably correctly disallows the same. Now, Lord, in respect of the other assessment year and the assessment order, 99-2000. Yes, Lord, in ITTA 92. 154 of 2006. Lord, ITTA 154 of 2006.
On the point of bad debt.
Yes, Lord, on the point of bad debt, but how the assessing officer are treated in respect of the other assessment year also. Now we are concerned with 2 assessment years. Here also, Lord, the assessing officer, I'll just briefly go through for 2001 is nothing like it. 99-2000 is a previous year. Nothing corrected. Yeah. Bad debts. That is addition of 15 crores and not SC has debited an amount of so-and-so on account of bad debts. With effect from assessment year 88-89, SC started claiming for the first time. Lord, on almost similar lines, Lord, he passes this order. But then, Lord, in addition, at page 17,
154 item number.
he only refers not to several other judgments.
Just 1 minute, 1 minute.
Yes. Now, in fact, not the issue as such. Same Tamil Nadu royalty page.
One can reach the claim. Keeping this like that.
Yes.
No. Now, as a submitted blood, the issue as such blood was settled by this Honorable Supreme Court. The only question is whether the tribunal blood accords with the judgments of the Honorable Supreme Court. Now, blood, page 17. In addition, he only refers to blood
Page 70 or what?
of blood ITT 154 of 2006. Blood assessment order starts at page 16. Blood
16.
16. Then, but at page 17, but he finds this same facts to apply here also. But in para 2.1, what about after referring to ITCL case, India Thermit Corporation Limited case, not says since there was a ray of hope, he did not allow in the above case department. Then again, he says, by amendment to section 36(1), no blank permission was given to the SRT to write off any amount. Under the circumstances, tribunal held law prior to amendment, SC has to establish that it become recoverable. In the amended provisions, SC is entitled. One cannot ignore the inclusion of the word bad prior to debt. This prior condition for allowability of the deduction under section 36(1)(7), even after the amendment provisions, cannot be lost sight of. Once a debt is established to be bad, deduction will be allowed in the year which the SC so. Besides, as per provisions of 36(1)(7), amount of any bad debt part thereof is written off as irrevocable in the account of the SC in the previous year is allowable subject to provisions of 36(2) Income Tax Act. The provisions of subsection 2 of 36 provides that no deduction shall be allowed unless such debts or part thereof has taken into account for computing the income of the SSC of the previous year in which the amount of such debt or part thereof is written off or an earlier year or represents money lent in the ordinary course of business of banking or money lending which is carried on by the SC. As discussed above, the SC is running the business of chit funds. The SC's business cannot be construed as banking. Therefore, in view of the provisions of section 36(1)(7), read with section 36(2) of the Income Tax Act, the amount claimed as bad debt but not offered as income in any earlier previous year, it cannot be claimed as bad debt. This is finding insofar as this year is also concerned. Now, Lord, coming to the decisions of the Supreme Court, Lord, where Lord, second one. Another form. Second form. May I just note down? Yes, Kathy.
Yes.
May I just pass on? This the case of Principal Commissioner of Income Tax versus Kathy Realtors Private Limited, reported in 2022, 447 ITR 167. But this was, of course, a case where in the course of their business, not they had claimed certain bad debts and claimed it both as having given up on the debts and also as an expenditure under Section 37. But Honorable Supreme Court deals with both the issues and also deals with the earlier decisions of the Honorable Supreme Court on these issues. But reliance is placed by the other judgments that they have produced, when they have filed before this Honorable Court or the Madras High Court, where TRF decision is also mentioned and they rely on. In fact, the Honorable High Court relies on that. Your Lordship will note, except the latest decision of the Madras High Court, which deals with this very same issue in the case of the very same SSC, which they have filed in their compilation. Except for the latest one, which is also brought to Kathy. Kathy's is dated Kathy is dated 25th August 2022. But the Madras High Court latest one is, I think, 21. And then there are earlier decisions also. I'm stating that because the very same SC is there before the Madras High Court on the very same issues. They have held in favor of the SSC. But I would like to distinguish those. That is the reason. Therefore, it is very important, before they rely on those decisions, for me to take your Lordship through the entire judgment of Kathy. But at page 170, note at the bottom they refer to the judgment of the Bombay High Court. Sorry, this is the High Court judgment, wherein the Honorable High Court felt that there was no question of law involved. The finding of the tribunal in that particular case, at page 171, if your Lordship takes third para, the tribunal referred to the object clause of the company and came to the conclusion transaction undertaken was part of the business activities. It was noticed that the SC was engaged in development review. Tribunal noted the fact that the amount had become irrevocable was not in dispute. In that view of the matter, tribunal was of the opinion loss was the SC's business loss and was required to be allowed under Section 37(1). Therefore, in the result, no question of law arises is how the Bombay High Court. But in our case also, the tribunal said, if it is bad debt, write it down. I mean, you have to allow it. Then coming to the judgment of the Supreme Court, at page 172, the SC carries on real estate development business, trading in transferable development rights. In respect of assessment year 910, the SC officer issued a notice under 143(2). The SC filed its response. The scrutiny assessment was complete by the SC officer, determining the total income. So SC contended that the amount of 10 crores deposited with so and so towards acquisition of premises 2 years prior to assessment in question. It was contended the project did not appear to make progress and consequently SC sought to return the amount sought the return of the amounts from the builder. However, the latter did not respond. As a result, the SC's board of directors resolved to write off the amount as bad debt in 2009. Also contended that the amount could be construed as loan since the SC had financing one of the objects. As SIC officer, the SC had stated, we submit that as per provisions of section 36(2), in respect of monies advanced in the ordinary course of business, the same is allowable as bad debt, even if the amount has not been taken into account in computing the total income. These are well accepted position in respect of write-off of advances given in the lending business. The present case fully falls within the provisions of section 36(2). Hence, the write-off of advances is allowable under section 36(1)(7). The assessing officer disallowed the sum of 10 crores claimed as bad debt in determining its income from under profit and gains of business or profession. Aggrieved, the SC appealed. But the appellate commissioner confirmed it. Then which, as your lordships have noted, was allowed by the tribunal, and appeal was rejected by the Bombay High Court. Then at page 174, 5 note, paragraph 5, the revenue contended that 36(1)(7) of the Act gives benefit to the SSC to claim a deduction, that is before the Supreme Court in the present appeal. Revenue contended that 36(1)(7) of the Act gives benefit to the SC to claim a deduction on any bad debt or part thereof, which is written off as irrevocable in the accounts of the SC for the previous year. This benefit is subject to subsection 36(2) of the Act. It is obligatory upon the SSC to prove to the assessing officer that the case satisfies the ingredients of both section 36(1)(7) and section 36(2) of the Act. It was urged that the Income Tax Appellate Tribunal and the High Court erred in accepting the SC's contentions, which were not supported by any material or document. It was submitted the SC's claim of giving 10 crore, but the alleged project was not substantiated by any material. Additionally, SC had also pleaded amount was given as loan to the developer, which was different plea altogether. This plea was bereft of any material as to the terms of the loan or the condition of prepayment, including interest. It was submitted that by virtue of section 36(2) of the Act, the assessing officer has to be satisfied that the action of writing off is on sound and reasonable basis and not a device. Reliance was placed on Catholic Syrian Bank Limited versus CIT. 343 ITR 270 to urge that the SC is obligated to prove to the assessing officer that the claim satisfies the ingredients of both section 36(1)(7) on the one hand and section 36(2) of the Act as well. These on the issue of bad debt brought under 36. Then coming to 37, Revenue further argued that the SC submission that the amount could alternatively be deducted as expenditure exclusively laid out for commercial purpose under 37 of the Act was belated and raised for the first time. That's the only stand the Revenue took. The Honorable Supreme Court has held in this particular case that you can never go under 37 when the case falls under 36. But I'll take your lordship. Then Kavita Jha, learned counsel for the SC, urged this court not to interfere with the matters. So she highlighted the following facts and circumstances which are not in dispute. The SC was engaged in business of real. The objects of the memorandum of so reflected the business of contract, erectors, as well as the receiving of lending money. 10 crores was advanced to Bansali to acquire. Then 4. The said 10 crores was written off during the assessment year 2009-10. 10 crores advanced to Bansali was in the ordinary course business. It was contended that since the builder borrower defaulted in payment of the amount, respondent SC decided to write off the same as a bad debt under 36(1)(7), read with section 36(2) of the Act. It was contended that after the amendment of section 36 of the Act in 1989, there was virtually no scope for the assessing officer to scrutinize in detail a decision to write off the debt. Counsel relied on the decision of this court in TRF Limited versus CIT. Ms. Jha further contended that there was nothing in the Act which barred an SC from claiming a benefit of 37 of the Act, of section 37 of the Act, in a case where expenditure was laid out or incurred exclusively for business or commercial purposes, where it might not be successful to establish its claim for deduction under any other head. Then wrote final analysis and conclusion of the Honorable Supreme Court. Section 36 of the Act occurs under other deductions, and its relevant extract for the purpose of the case is as follows. 36.1. Deductions provided for in the following clauses shall be allowed in respect of matters dealt with therein in computing the income referred to section 28. Then straight away they come to clause 7 of 36.1. Subject to the provisions of subsection 2, the amount of any bad debt or part thereof which is written off as irrevocable in the accounts of the SSC for the previous year, provided that in the case of an SSC to which clause 7A, not scheduled banks, we are not concerned with it. Say 7A relates to scheduled banks, we are not concerned with that. Then we are also not concerned with the other proviso, explanation 1, which was there even at that point of time and is even as of now. For the purpose of this clause, any bad debt or part thereof written off as irrevocable in the accounts of the SSC shall not include any provision for bad and doubtful debts made in the accounts of the SSC. Then in subsection 2, in making any deduction for bad debt or part thereof, following provisions shall apply. 1. No such deduction shall be allowed unless such debt or part thereof has been taken into account in computing the income of the SSC of the previous year. But this is also with effect from 1/4/60/14. Anyway, even not, I'll just read through. A debt or part thereof written of an earlier
Let
previous
us
or
come to
present
the
source.
let us come to the discussion of the final conclusion of the.
Yeah, I'll just yes, but I'll take your lordships the final findings. Before that note, at page 177, the bottom note, para 11, after referring to 37, the income of every SSC has to be assessed according to the statutory framework laid down in Chapter 4, Part D of the Act. The chapter deals with heads of income. Section 28 of the Act deals with the chargeability of income to tax and net profits and gains of business or profession. The other deductions that an SC can claim, elaborated under Section 36 of the Act, which opens with the phrase, the deductions provided for in the following clauses shall be allowed in respect of the matters dealt with therein in computing the income referred to in Section 28. For the purpose of computing income chargeable to tax, therefore, besides specific deductions, other deductions enumerated in different clauses of Section 36 can be allowed by the assessing officer. Then coming to page, lordship may straight away come to, after referring to Southern Technologies, where the position of law on this subject has been spelled out in Southern Technologies and clearly approved by this honorable, this bench. Is at page 178, para 13. With effect from 1/4/2089, because we are concerned with after 1/4/89, insertion of new explanation in 36(1)(7), any bad debt written off as irrevocable in the account of the SC would not include any provision for bad doubtful debt made in the accounts of the SSC. In other words, before this date, even a provision could be treated as a write-off. However, after this date, explanation to Section 36(1)(7) brought about a change. As a result, a mere provision for bad debt per se was not entitled to deduction under Section 36(1)(7). This position in law was recognized by this court in Southern Technologies Limited versus Joint CIT. Para 25, the court note, by insertion with effect from April 1, 1989 of a new explanation in 36(1)(7, it has been clarified that any bad debt written off or as irrevocable in the account of the SC will not include any provision for bad and doubtful debt made in the accounts of the SC. Said amendment indicates that before April 1, even a provision could be treated as write-off. However, after April 1, 1989, a distinct dichotomy is brought in by way of the said explanation to 36(1)(7. Consequently, after April 1, 1989, a mere provision for bad debt would not be entitled to deduction under Section 36(1)(7. To understand the above dichotomy, one must understand how to write off. If an SC debits an amount of doubtful debt to the profit and loss account and credits the asset account like sundry debtors account, it would constitute a write-off of the actual debt. However, if an SC debits provision for doubtful debt to the profit and loss account and makes a corresponding credit to the current liabilities and provisions on the liability side of the balance sheet, then it would constitute a provision for doubtful debt. In the later case, the SC would not be entitled to deduction after April 1, 1989. The point to be noted is that the income tax is a tax on real income, that is, profits arrived at on commercial principles subject to the provisions of the Act. Therefore, by explanation to section 36(1)(7), a provision for doubtful debt is kept out of the ambit of bad debt, which is written off then. One has to take into account that the said explanation in computation to total income under the Act, which cannot ascertain the real profits. That is where the concept of add back comes in. In our view, a provision for non-performing asset debited to P&L account under 1998 directions is only a notional expense and therefore would be added back to that extent, computing the total income under the Income Tax Act. Then, finally, after then referring to Catholic Syrian Bank, at page 180, at page 179 bottom, it is thus evident that merely stating a bad and doubtful debt as irrevocable without the appropriate treatment in the accounts, as well as non-compliance with the conditions in section 136(1)(7), 36(2), and explanation to section 36(1)(7), would not entitle the SC to claim deduction. The position was again reiterated again in Catholic Syrian Bank. The language of 36(1)(7) of the Act is unambiguous and does not admit of two interpretations. It applies to all banks, commercial, rural, so on. So it gives a benefit to the SSC to claim deduction on any bad debt or part thereof which is written off as a reward. This benefit is subject only to 36(2). It is obligatory upon the SC to prove to the assessing officer that case satisfies the ingredients of 36(1)(7) on the one hand, and it satisfies the requirements stated in section 36(2) of the Act on the other. The proviso to 36(1) does not, in absolute terms, control the application of this provision, and it comes to operation only when the case of the SC is one which squarely falls under 36(1)(7)(a), that is in respect of banks. We may also notice that explanation to 36(1)(7) introduced by Finance Act has to be examined in conjunction with the principal section. The explanation specifically excluded any provision for bad and doubtful debts made in the account of the SC from the ambit of scope of any bad debt or part thereof written off in the accounts of the SC. Thus, the concept of making a provision for bad doubtful debts will fall outside the scope of 36(1)(7) simpliciter. The proviso, as already noticed, will have to be read with the provisions of 36(1)(7)(a). In fact, they say that. Then, the SSC has relied on the ruling in TRF, which I have already referred to, where the Madras High Court was also told. This position in law is well settled. After the April 1, 1989, it is not necessary for the SC to establish that the debt in fact has become irrevocable. It is enough if the bad debt is written off as irrevocable in the accounts of the SC. However, in the present case, the SC officer has not examined whether the debt has in fact been written off in the accounts of the SC. When bad debt occurs, the bad debt account is debited and current customer's account is credited, thus closing the account of the customer. In case of companies, the provision is deducted from sundry debtors. As stated above, the assessing officer has not examined whether in fact bad debt or part thereof is written off in the accounts of the SC. This exercise has not been undertaken by the assessing officer. Hence, the matter is remitted to the AO for de novo consideration of the above mentioned aspect only, and that too only to the extent of write-off. Now, this court, adverting to TRF, Honorable Supreme Court says, this court did not examine the impact of section 36(2) of the condition to write-off in the accounts of the SSC during the previous year in TRF Limited, Supra. However, the judgments in Southern Technologies Supra and Catholic Syrian Bank Supra spelled out the conditions subject to which the SC could write off as a bad and doubtful debt. Interestingly, Kapadia CJ was a party to TRF Limited and Catholic Syrian, they take little different views, Catholic Syrian Bank. He is in fact authored the judgment in Southern Technologies. Furthermore, Catholic Syrian Bank is by a bench of 3 judges, whereas the other decisions are benches of 2 judges. In the circumstances, this court has to accord primacy to Southern Technologies. Then it is evident from the above rulings of this court that 1. The amount of any bad debt or part thereof has to be written off as irrevocable in the accounts of the SC for the previous year. 2. Such bad debt or part of it written off as irrevocable in the accounts of the SC cannot include any provision for bad doubtful debts made in the accounts of the SC. 3. No deduction is allowable unless the debt or part of it has been taken into account in computing the income of the SC of the previous year in which the amount of such debt or part thereof is written off, or as a previous or of a and earlier previous year, or represents money lent in the ordinary course of business of banking or money lending which is carried on by the SC. 4. The SC is obliged to prove to the assessing officer that the case satisfies the ingredients of section 36(1)(7) as well as section 36(2) of the Act. In the present case, the record shows the account of so and so nowhere shows that the advance made by Bansali in the ordinary course of its primary argument was the amount of 10 crores due to so on. However, the amount was written off on so and so as noted by the Commissioner of Appeals. There was no material to substantiate the submission in respect of payment of amount, the time by which the constructed unit was to be given to, the area agreed to be purchased, etc. Equally in support of the argument that the amount was given as a loan, SC nowhere established duration of the advance, the terms, conditions applicable to it, interest payable, etc. The SC considered that it had received interest income for 11 years. However, it could not establish that any interest was paid or shown to be payable in its accounts for the sum of 10 crores. Furthermore, there is nothing on record to suggest that requirement of law that the bad debt written off as irrevocable in the SC's accounts for the previous year has been satisfied. Another reason why the amount could not have been written off is that the SC's claim was that it was given to Bansali developers for acquiring immovable property, which therefore was in the nature of capital expenditures, not have been treated as a business expenditure. Then they refer to A.V. Thomas case. But that is whether it's a business expenditure. And then finally, in para 19, in view of the above discussion, is held that SC's claim for deduction of 10 crores as bad and doubtful debt could not have been allowed. Findings of the tribunal and High Court to the contrary are therefore have to be set aside. Then the second issue relates to, so therefore, as far as bad debt is, that's the finding of the Honorable Supreme. Even on merits. Here also your Lordship will find, but the assessing officer has noted how much they could not, there was no attempt also, and even 1 day account was treated as bad debt, just as a 12-month period, etc. Then the second issue relates to admissibility of expenditure as a deduction which does not fall within the provisions of 48 to 43 and is not capital in nature but is laid out or spent exclusively for the purpose of business under section 37 of the Act. Then the similar provision that existed but under section 36 under the old Act. Then finally coming to the question whether or not on account of bad for business or whether it was a capital stream. In the facts of the case, this court is of the opinion that as a proposition of law, That enunciation is unexceptional since the heads of expenditure that can be claimed as deduction are not exhaustive, which is the precise reason why the existence for the existence of 37. Therefore, in a given case, if expenditure relates to business and the claim for its treatment under that other provisions are unsuccessful, application under 37 per se not excluded. This court is of the opinion, however, that in the facts of this case, judgment of Southern Technologies is appropriate. As stated above 3617, after it draws the distinction between write-off and provision for doubtful debt. The Act deals only with doubtful debt. It is for the SC to establish provision is made as the loan is irrecoverable. However, in view of explanation which keeps such a provision outside the scope of the written off bad debt, section 37 cannot come in. If an item falls under 30 to 36 but is excluded by an explanation to 3617, then section 37 cannot come in. Section 37 applies only to items which do not fall under 30 to 36. So this also settles the issue which has been subject matter of consideration by various courts earlier. Whether an alternate claim under 37 can be made, as was claimed also by the SC in this case also. If a provision for doubtful debt is expressly excluded from 3617, then such a provision cannot claim deduction under 37 of the Act, even on the basis of real income theory, as explained above. So, by reliance, insofar as this issue is concerned, is on this judgment, and my submission is that the tribunal's order, insofar as that issue is concerned, is liable to be set aside. But if you are satisfied with what the assessing officer has already undertaken, you will not change to that. As per me, it was good enough. It need not further go into the issue, even as per what the Supreme Court has said. That is the first issue. The other issues are royalty and commission. But may I just briefly take your lordships to the issue of royalty payment. Where is the issue of chits and chits? Chits is not a big issue. No. Not on the issue of there are two more issues. Not one is cancelled chits. Page
Now,
40.
Bad debt, insofar as bad debt, your submission is over.
My submissions are over. I have also referred to their judgments where I say, probably because they were earlier in point of time. Then page 40, insofar as cancelled chits are concerned, that is one of the issues. We say that we rely on the orders of the authorities, because that's a fact finding that we can't really go into. On the issue of royalty, though, I would like to
No, from this compilation, the questions which were
yes, Lord, if you not
1, 2, and 3 is regarding bad debts.
1, 2, and 3 are bad debts.
4 is
royalty payments.
which you say
They claim that it's an allowable and expenditure under section 37. We say no. It brings an enduring benefit to the SSC. It has to be capitalized. It's a complete capital outlay for them. But I'm only relying on one judgment of the Honorable Supreme Court, that is Honda CL. But where they have considered various other judgments which was referred to by the tribunal also, SEBA and Wavin and other cases. Wavin came subsequently. Then the last issue is regard to commission on removed checks.
so this question on royalty payments,
Yes.
you are not insisting.
I'm only relying on the Supreme Court judgment where I'll just take your lordship. This is a case where
Either you
in
say,
Honda CL, yes.
you are pressing this or you are not pressing this.
No, we can't say we are not pressing it. On commission, we are relying on the judgment tribunal's orders. I mean, the authorities' orders. That is the AO and the appellate commissioner. But insofar as royalty is concerned, there is an issue to be considered, because in case of Honda CL, Supreme Court, Honorable Supreme Court, no doubt dealt with the case where it was first time business. Here also what we say is, it's a subsidiary of the main company. We are allowed to, our very existence, that is the SC's very existence, is on account of the mother company. They pay royalty to the mother company. Without their complete cooperation and establishment, their advice, etc. I'll take your lordship to what the findings are. Then without that, they could not be in existence at all. They could not survive in the business. So it was a complete outlay, just as in Honda CL's case, where the Japanese company, joint venture company, gave to the Indian subsidiary a complete assistance by way of technology and all that. Only thing, it was a newly set up plant, they say. Yes, even in this case, without the very existence is because of the mother company, to whom they are paying royalty. So whether it amounts to being a new one, a nascent one. Without them, they would not survive. So I am only relying on Honda CLs. I'll leave to your lordship. I'll just cite the judgment and leave it to your lordships. But the findings are in para 6.7 at page 51. Note this is where before the tribunal also we had relied on respectfully following the same. Briefly, I'll just state the facts here, bro, and go to the judgment. Facts are not in dispute that SC has paid royalty to Sriram Chits and Investments for the use of their name and logo in chit business. Only ground of disallowance, that is the prior assessment years, no such payment is made. For the first time, from that year, they claimed mine. The disputed facts are that the logo and word Sriram Chits is owned by Sriram Chits and Investments Private Limited. And SC has used this valuable property and use of such name and copyright and helped the SC in establishing its business. It is also not disputed that other group companies in Tamil Nadu, Karnataka were using the same name and logo of Sriram and are having royalty agreements with the parent company and are paying royalty, and that these royalty payments having been allowed in the case of Karnataka company by the Bangalore bench of the tribunal and in the case of Tamil Nadu company by the Commissioner of Income Tax Appeals. Not in dispute that the finding of the Commissioner that the royalty payments have to be allowed in the case of Tamil Nadu have not been challenged, but that is not relevant because they have challenged it in other cases. In fact, Madras High Court, where they have filed in their compilation, has dealt with this issue also, where we relied on Honda CL. Honda CL judgment are filed before your lordships, not the second judgment note along with this. The final conclusion, I won't take your lordship's time on this because then after referring to the judgments in the case of Hero Honda of Delhi High Court as well as SIBA, Supreme Court. May I just take your lordships to the last. Now, after referring to Alembic and what Alembic has said about in its judgment at page 186, para 24.
Yes.
If the technical know-how obtained under agreement for which technology is paid is for a limited period only and only right to use the technical know-how is there during the agreement, no right of accession, coupled with the fact that the said technical know-how is utilized for improvising the existing expenditure would be treated as revenue. This case thus gives an indication that if such technical know-how is for the purpose of setting up new business, the position may be different, as in our case, as according to us. Another aspect which needs to be noted is that while rendering the opposite, this court observed that there is no single test or principle or rule of thumb which is paramount. It is ultimately a question of law, but a question which must be answered in the light of all the circumstances which are reasonable to take into account, and the weight which must be given to a particular circumstance in a particular case must depend on the common sense rather than strict application. This one consideration may point so clearly that it dominates one. So then this court also said that the idea of once for all payment and enduring benefit are not to be treated as something akin to a statutory condition, nor are the notions of capital or revenue a judicial fetish. What is capital expenditure and what is revenue are not eternal varieties, but must need to be flexible so as to respond to the changing economic realities. Expression asset or advantage of enduring nature was evolved to emphasize the element of a sufficient degree of durability appropriate to the context. When we apply the aforesaid parameters to facts of the present case, conclusion drawn by the High Court that expenditure incurred was capital nature appears to be unblemished. Admittedly, there was no existing business, and thus question of improvising the existing technical know-how by borrowing the technical know-how from HMCL Japan did not arise. The SEC was not in existence at all, and it was the result of joint venture of so Japan and HSCL India. Very purpose of agreement by the two companies was set up a joint venture company with the aim and object to establish a unit of manufacture of automobiles and part thereof. As a result of this agreement, the SC company was incorporated with which entered into TCA with in question for technical collaboration. This technical collaboration included not only transfer of technical information, but complete assistance to bring in existence manufacturing unit for the products. Thus, the new business was set up with technical know-how provided by HMCL Japan and lump sum royalty through, though in 5 installments was paid thereof. No doubt this technical know-how is for the limited period, that is for tenure of agreement. However, it is important to note that in case of termination of agreement, joint venture itself would come to an end and there will not be any further continuation of manufactured products with technical know-how foreign collaborator. High Court has thus rightly observed that virtually life of manufacture of product is a plant and machinery established with the assistance of foreign company is coextensive with the agreement. The agreement is framed in a manner so as to give color to the license for limited period, having no enduring nature. But when a close scrutiny into the said agreement is undertaken, it shows otherwise. It is significant to note in this behalf that the agreement provides that in the event of expiration or otherwise termination whatsoever, licensee, that is joint venture company, SSE, shall discontinue the manufacture, sale and other disposition of products, parts and residuary products. All these things then shall at the option of the licensor, in other words, licensee in such contingency would hand over unsold product and parts to licensor for sale by him. In this case, licensor does not exercise such an option and product is allowed to be sold by the licensee. It would continue to pay royalty as per rates agreed under the agreement. In our view, make the clause 1921, in our view, make the agreement in question, that is establishment of plant, machinery, manufacture of product with the help of technical know-how, coextensive in continuance of the agreement. The agreement has also a clause for renewal, which our view in totality of terms and conditions will make the unit continue so long as manufacture of products in plant and machinery established with the aid and assistance of foreign company will continue. Since it is found that the agreement in question was crucial for setting up plant project in question for manufacture of goods, the expenditure in the form of royalty paid would be in the nature of capital expenditure and not revenue. Tribunal's conclusion that it is only the other 3 memoranda which are necessary for setting up manufacturing facilities and not the payment of technical fee royalty slash royalty on the ground that this agreement was not in connection with the setting up plant or manufacturing facilities is not correct. Interesting.
Yes, what is the ultimate conclusion?
Ultimate conclusion not is that not dismissing the SC's appeal, holding not that anything that it did not necessarily be a permanent agreement also, even a renewal agreement. Basic conclusion would be this, where assistance is given to set up or establish or to and to follow with the new business of the SSC, or in the continued running of such business, and providing assistance in several different manners. In fact, their people from the holding company, they go to the SSC's company, they assist them in all sort of manners, training, etc., which is all given in the orders of the commissioner as well as assisting officer.
Or court officer. We'll come back after lunch. We'll rise up.
Your Lordship's permission. Item 54 is a covered matter.
Yes, Mr. Prasad, you have completed? You have completed? Please tell us something. We are in a state of confusion. Yes.
The business of the assessee, that of a chit fund. In the course of the chit, there are persons who take the chit in auction who are called priced subscribers. Those who don't take the chit in the auction and continue profits of the assessee. It's a continuing process. Every day there are chits, there are several groups, so it's a huge transaction. So there is substantial dividend which is distributed amongst the chit subscribers, which includes the assessee also. Now what happens after some time, the priced subscriber makes some default. When he makes a default, which means he doesn't contribute to the monthly installments of the chits. So what happens, it becomes a duty under the agreement, it becomes a duty or responsibility of the company through the foreman to make good that installment. For supposing he doesn't pay the installment of 10,000 rupees this month, in the course of the business, and the income from the debt in the sense of dividend, which has already been taken into account. Well, the department's objection here seems to be as a two.
It's a very long section.
36(1) has got some kind of 18 subclauses which gives a deduction. At the end of it, we don't know whether it is a deduction or it's a subsection 2 of 36.
Yes.
It reads in make
1.34.
in making any deduction for a bad debt or part thereof, the following provisions shall apply. 1. No such deduction shall be allowed unless such debt or part thereof has been taken into account in computing the income of the assessee of the previous year in which the amount of such debt or part thereof is written off, or of an earlier previous year, or represents money lent in the ordinary course of the business of banking or money lending which is carried on by the assessee. Now the question is whether I have taken into account this debt in computing my income. It doesn't say that the entire debt should have been taken, the subscription as they put it in the assessment order. The entire subscription which is paid by the subscribers, that need not be shown as my income. What is to be shown as income, what is to be done is that debt should be taken into account. I have taken into account the dividend which initially was available to me when the price subscriber took the chit in the auction. Therefore, this condition is satisfied. In fact, they don't dispute this. They only want a further requirement. They want to read a further requirement in the section which is not there in the section by saying that the entire amount has to be shown as income. That is not the requirement of the section. That is my submission. Lord, this, apart from this, Lord, this identical question, I have written it off. They have not disputed that. The entire debt has been written off. What has happened is, for the first 2 years which your lordships have disposed of on the ground of tax effect, 95, 96 and 97, 98. In those years, the method I adopted for writing off the debt is I waited till the entire chit came to a close. The period of chit may vary from 1 year, 1.5 years, 2 years. I waited till the entire chit came to an end and then wrote off the defaulted amount. Now what I found was that it was a long period. My experience showed that those who default for about 4 or 5 installments, they never pay. So what I did from the assessment year 98, 99 onwards, which is what the tribunal also has referred, on the basis of the past experience, I waited for 4 installments which are defaulted. After that, I wrote off the amount. I did not wait till the end of the chit. So this is the tribunal has recorded a finding of fact. I will take your lordship through very briefly, that the earlier method was also a good method and it's a bona fide method, a honest decision, but the changed method is based on past experience and also on the Reserve Bank norms, and therefore that's also honest decision. So all the conditions are satisfied. One, that the income has been taken, debt has been taken into account in my accounts by showing the dividend. Number 2, it has been written off. And number 3, whenever there are recoveries of the bad debt which is written off, I have shown it as income. But only once, I have filed the typeset index 2 like this. But this here I have placed a chart at page 151. Gives a bird's eye view of the position with regard to bad debts for about 20 years.
151.
151. The lordships have got the columnar chart.
Yes.
So for the first 4-5 years, 89, 90 to 94, 95, lordships have the footnote. Bad debts deduction claim was allowed by the assessing officer in the assessments up to the assessment year 94, 95. They had no objection to allowing this as bad debt. Now, our lordship can also see that there is a recovery of bad debts, last column.
Yes.
All that recovery has been declared as my income in the return. So there has been no escapement. Now, if the bad debts are disallowed, it will amount to double taxation in the sense bad debts also gets disallowed. The recoveries which I have offered to tax, there is no provision in the act for me to exclude it from my income for those years. So that will be one double addition. Therefore, tribunal took care of all these things. Only 2 places, 2 paragraphs, the observations of the tribunal. Paragraph 6.6, 20 and 21. 6.6, 20 and 21, which is at page 50.
Yes.
Internal page 50 of the tribunal's order. Paragraph 6.6, 20. On these facts, a claim of loss without corresponding inflow of funds from the foreman, which is a definite possibility in this method of claim, cannot be upheld. The amount of loss can definitely be allowed to the extent that the foreman has put in his funds and has come to a conclusion that his funds are not recoverable due to the amount becoming sticky, and to the extent he has taken an honest decision for writing off the same in his books. In other words, bad debts can be allowed to the extent of the installments defaulted by a priced subscriber and written off as bad debt in the books by the assessee. But for the future installments that are likely and yet to be defaulted, no claim can be allowed, no difficulty. The assessing officer cannot replace the judgment of the businessman. Now, next sentence. The facts that the assessee has written off as bad debt when priced subscribers defaulted for 4 consecutive months does not, to our mind, affect his claim, as this is based on past experience of the assessee in his business and is in tune with the current RBI norms for NBFCs as well as for banking companies. But therefore, it is a very honest decision to change the earlier method, which I was hitherto adopting, and to introduce a new method that after 4 consecutive defaults, I take a decision that this man is not going to pay anymore. Therefore, those installments I have written off. The future installments I have not written off. The tribunal directed an inquiry to be made by the assessing officer as to whether the future installments which are not yet due, whether they have also been written off. I said no, but the tribunal wanted a verification. After verifying, the assessing officer is satisfied that the claim is restricted only to the 4 consecutive installments which have fallen due. Therefore, I have not made any excess claim also. But this is the position with regard to bad debts. Now, your lordships may see much reliance was placed on the judgment of the Supreme Court. Before that, my lordships will only see this issue arose in number of group companies. So the Sriram group has got companies, chit companies in Tamil Nadu, Karnataka as well as Andhra Pradesh. So this issue of bad debts arose directly before the Madras High Court. But I have placed that order of the division bench of the Madras High Court. Your lordships will have this blue spiral book, which is titled the Paper Book Department Appeal. Yes. In that, page number 4. Page number 1, I'm sorry, page number 1. That is a judgment dated 3rd of April 2012.
There is no internal pagination here.
Oh, I see.
Anyway,
it's marked in green. It's a thick book.
but inside there is no internal pagination. Because how do we go to each page? There is no internal pagination.
Is it page or internal page?
Anyway.
We'll give this.
What is the case?
That is a judgment dated 3rd of April. 3rd of April 2012.
Yes. कहाँ पर? कैसे नहीं? Anyway. Yes.
But this is a judgment of the division bench of the Madras High Court, which raises the identical issue of bad debt.
Yes.
But basically, when my learned friend read out the tribunal's order, there was a reference to the circular issued by the Central Board in 1978. But this issue of bad debt has engaged the attention of the Central Board also in the case of chits. So they issued an instruction saying that don't treat this bad debt as a separate category apart from, please give the treatment which you will accord to a bad debt in a regular business. The same treatment has to be given to this chit fund also. That was the circular issued in 1978, and that is referred to by the tribunal's order. And Madras High Court also relies on the tribunal, on the CBDT circular to say that when the board itself has taken the view that these are to be allowed as bad debts, subject to conditions being satisfied, they have to be allowed. The High Court also dealt with the alternative claim that it is a business loss. Otherwise, that was a very short paragraph, but there is not much of reasoning in that. But the main reasoning is in support of the bad debts claim. But they have examined the relationship between the priced subscriber and the chit fund and the company and said there is a debt created when he takes the chit on auction because he promises to repay the debt along with interest. And if he doesn't repay, it becomes bad, then it is a bad debt, and therefore the bad debt can be written off and can be claimed subject to the conditions being satisfied. So that is the entire summary of this decision. I understand that the department has accepted the decision, has not filed any special leave, and this has been followed throughout by the Madras High Court in the subsequent orders. I am not troubling your lordship. They are all short orders following this order. This is the main order where they have main judgment, where they have said that 3617 read with 36.2 stands satisfied in the case of the assessee, not this assessee, another assessee of the same group company. But I would only respectfully submit that because it's the same group, the uniformity of judgments is a desirable thing. Therefore, in the absence of any other facts, any peculiar facts, this judgment, I would respectfully appeal to your lordships that this may be taken note of in deciding the matter. Well, this is the, and all the findings of the tribunal that this section is satisfied, they are all findings of fact. The decision is bona fide, that there is write-off and all that. They are all findings of fact. They have not challenged that the findings are perverse.
Yes. Only take us through the relevant portion of the
Yes.
Madras High Court.
Madras. Not this, but print is very small. I will read it. Paragraph 9 onwards. Your lordship will see only paragraph 9 on. At para 9, in order to decide on the rival contentions made, it is necessary to get into the decision of the Apex Court in AAR 1993 Supreme Court so and so, a decision which dealt with the virus of the Chit Funds Act. Lord, I need not read the whole thing. What happened was, the department had taken a stand that the decision of the Supreme Court says that there is no relationship of debtor-creditor between the chit fund and the price. Para 11. Keeping this declaration of law, when we look into the provisions of the Chit Fund Act, one may note the obligation of the foreman, particularly as given under section 21. While enumerating the rights of the foreman, the Act also takes care to impose an obligation on the foreman to do all acts which may be necessary for the due and proper conduct of the chit under subclause F, which empowers the foreman to substitute the subscriber in the place of the defaulting subscriber. As far as the duties of the foreman as enumerated under section 22(2) of the Act is concerned, the Act stipulates that in the event of default by a priced subscriber, in respect of the price amount due, in respect of any draw remaining unpaid till the date of the next succeeding installment, the foreman shall deposit the price amount in a separate account in an approved bank mentioned in the chit agreement. The Act also provides that where the priced subscriber does not collect the price amount in respect of any installment of a chit within a period of 2 months from the date of the draw, it shall be open to the foreman to hold another draw in respect of such installment. The section also provides that the foreman may appropriate to himself the interest accruing on the amount deposited under the second proviso to subsection 1 for which he is entitled. As far as the balance sheet of the company is concerned, section 24 enumerates what is required to be stated in the balance sheet. The rules therein provide for the format. A reading of the schedule as against the asset side shows loans and advances to subscribers as well as the liabilities as relatable to non-price subscribers. But their lordships find that the legal position is also in conformity with the accounting aspect, inasmuch as the price subscribers are shown as debtors, loans and advances, under the head loans and advances. The asset side also contains receipts of interest and such other amount which can be transferred to fall under the caption of assets. In terms of the provisions thus prescribed in section 24, the balance sheet and profit and loss account clearly showed the amount intimated by the company as against the default committed by the chit holders, and the balance sheet was also audited by the chartered accountant qualified to act as auditor under the Companies Act. In the context of the payment thus made, the question that arises herein is as to whether the activity of the assessee could be termed as falling under the status of a creditor, that on the debt amount advanced, the same could be characterized as a debt for the purpose of treating it under section 36(2) of the Chit Funds Act. It is a settled position of law as held in so and so TRF Limited that after the amendment to section 36(1)(7) of the Income Tax Act with effect from 1/4/1989, it is not necessary for an assessee to establish that the debt in fact has become irrecoverable, and it is enough if the bad debt is written off as irrecoverable in the accounts of the assessee. In the context of the different stand taken by the revenue in the year under consideration, in contradistinction to the earlier years, the terms of the claim of the assessee in earlier years assume significance. It is not denied by the revenue that in respect of the earlier years 1991 and 91-92, the claim of the assessee for deduction as a bad debt was allowed, and in the appeal preferred by the revenue before the tribunal. In the appeal preferred by the revenue before the tribunal referred to the clarification issued by the board dated 16th May 1997, which reads as follows. But I am not troubling your lordships with that. Only thing is, it says somewhere in the middle, it says, normally there should be no loss to the organizer unless he takes over the liability of some of the members. In such a case, the unrecovered amount due from such members will have to be treated as bad debts, and the test to be adopted in usual business assessment for the allowance of bad debts would be applicable in such cases also. So they say you don't make a distinction between other businesses and chit funds. Whatever law applies to the other businesses will apply to chit funds also. Para 15. The subsequent clarification issued on 25/3/1992, which has been extracted in the order of the tribunal relating to the assessment is so and so, merits to be extracted hereunder. They reiterate the earlier circular, which is in 1992. I am not troubling your lordships with that. Para 2, except para 2. The issues raised by you have been carefully examined by the board. In this regard, I am directed to say that the board are of the view that instruction number 1175 issued in consultation with the Ministry of Law cannot be withdrawn on the basis of the decision of the Punjab and Haryana High Court. In the case of soda silicate, the board's instruction stands. They reiterate. The board's earlier instruction is in paragraph 14, what the Madras High Court has already extracted. Then para 16. Having regard to the specific observations of treating the unrecovered amount of the subscriber and the debts as bad debt, the tribunal allowed the case of the assessee that the claim was to be construed as a bad debt, allowable as deduction under 36. In the background of the above facts, although we are inclined to dismiss the revenue's appeal, the decision taken by the Commissioner of Income Tax Appeals in respect of the above said claim merits to be noted herein. A perusal of the order of the Commissioner shows, as regards the responsibility of the foreman as listed under the Chit Funds Act, it is admitted by the parties herein that having regard to the obligation under the Chit Funds Act, the assessee had to pump in its own money for the purpose of ensuring that the chit cycle goes on as promised. It is an admitted fact that in respect of the shortfall due to non-payment, the company brought in its own money, which was utilized for running the chit business, and this did not stand in the way of the statutory obligation of the foreman in getting the chit cycles move on as before. Thus, with statutory obligation imposed and well in compliance of the said obligation, that the company had to pay its own money to have the successful chit circulated as before, as pointed out by the Apex Court. If there is an obligation under the special contract between the defaulted chit holder and the company, even if the amount due is not treated as a debt within the meaning of the Moneylenders Act, yet the contract gives rise to a relationship of a creditor and debtor. Thus, the Commissioner of Income Tax Appeals, having gone into the requirement of the provisions of the Chit Funds Act, held that the advancement of the money is part and parcel of the business, thus giving rise to a situation that when the defaulter did not make the payment to the company had to claim it as a bad debt for the purpose of deduction under section 36. But this is, thus they approve of the reasoning of the Commissioner who examined the provisions of the Chit Funds Act and came to the conclusion that when a price subscriber commits a default, there is a debtor-creditor relationship, and therefore there is a debt. But para 18 deals with the alternative claim. Before they go to the alternative claim, which is the claim of business loss, on the claim of bad debt, my learned friend laid on Kyati Realtors judgment of the Supreme Court. But what is the judgment? What are the facts of that case? Very shortly. Assessee was there in that case, was carrying on a real estate business as well as finance business. He advanced 10 crores of rupees to another company for purchase of commercial premises for its own use. It was capital expenditure. The moment it was capital expenditure, there is no question of it being allowed under any provision of the Act, whether 36 or 28 or whatever, 37, whatever section, nothing applies. 37 clearly says that wholly and exclusively for the purpose of business, not being capital expenditure. So the moment it was capital expenditure, my claim under 37, 36, everything fell apart. In addition to that, there, your lordships will only see paragraph 19 of that judgment as reported in SEC. But if your lordships have that SEC copy,
no, we have the ITR.
Then I will. ITR. Well, your lordships will, I have this SEC as well as taxman copy.
Oh.
I can refer to the paragraph. It starts with the sentence in the present case. It is para 19 in my this thing. In the present case.
Here it is not, there is no page, paragraph numbers here.
Yes, that is the difficulty. There is a para which starts with in the present case, the record shows.
Page 182. Down. Yes.
In the present case, the record shows that the accounts of the assessee nowhere showed that the advance was made by it to Messrs. Bansali developers in the ordinary course of business. Point number 1 against the assessee there. That is not so in my case. Its primary argument was that the amount of 10 crores was given for the purpose of purchasing constructed premises. However, the amount was written off on 28/3/2009. As noted by the CET appeals, there was no material to substantiate this submission, though the claim was made. In fact, the assessee contended even before the Supreme Court that it was written off. But in this paragraph, the Supreme Court found that claim was not correct. As noted by the CET appeals, there was no material to substantiate this submission in respect of the payment of the amount, the time by which the constructed unit was to be given, the area agreed to be purchased, etc. Equally, in support of its other argument that the amount was given as a loan, but the assessee there tried to relying on memorandum of association, tried to make a submission that I am carrying on finance business and therefore this is a loss in the course of the finance business. The Supreme Court found if that is so, where is the interest element? Where is the payment of interest and the receipt of interest? That was also not there. Then there is a sentence which starts, however, it could not establish that any interest was paid or shown to be payable in the accounts for the sum of rupees 10 crore. Then comes the crucial thing regarding 36. Furthermore, there is nothing on record to suggest that the requirement of the law that the bad debt was written off as irrecoverable in the assessee's accounts for the previous year had been satisfied. There are absolutely no material to show that it was even written off. Then a crucial condition of that section 30 these facts which are very gross in that case, there was no way either section 28 or different. The Madras High Court judgment which I just now read, where they upheld the Commissioner of Income Tax's reasoning, saying that this debt arose in the course of the in the course of chit business, is a finding which is in my favor, and that there is no dispute that this amount was written off in my books, and there is no dispute that this is a honest decision. To that effect, there is a finding also in the order of the tribunal. With all these, but my submission, very respectful submission, is that, and this judgment of the Madras High Court has subsequently been applied in the assessees there in the state of Tamil Nadu, but your lordships will take note of the judgment of the, not that your lordships are bound, but there is a persuasive value because it's in the case of the same group and the same provisions, the Chit Funds Act, are being applied, and therefore my respectful submission is the tribunal order need not be disturbed in respect of the bad debts claim. Mainly, my lord, I'm grateful. Mainly, they relied on the circular. The board itself says that don't treat this bad debt as something different from other businesses. It's the same kind of bad debt. So, accord the same treatment, which means if I satisfy section 36, I must be getting the allowance. These are my submissions insofar as bad debts are concerned. Well, the circular is already extracted in the judgment of the Madras High Court as well as in the order of the tribunal. I have also placed it separately for convenience at page 69 and 70 of this blue color compilation.
Yes.
Separately in bold type it is there. So that compilation contains all the judgments and the index is quite elaborate. Pages 69 and 70 of this.
But there is no pagination.
Oh. No, I will file I will substitute that with another number.
Somebody can paginate.
Paginate, yes.
Just give me a moment.
Page
69 and 70.
Yes.
Page 69 is the first circular of 1978, circular number 1175, which says accord the same treatment. The board says that accord the same treatment which you will give to a bad debt in other businesses. Don't treat it differently.
This is instruction number 1175.
75, yes. And and some official of the income tax department who came across a decision of the Punjab High Court, which related perhaps to this point, sought a clarification from the board, saying that whether in light of that judgment, the board's view will change. The board reiterated in 1992. That is the next page 70, page 70. It's a 92 circular, 25th March 92 circular, where they say, no, there is no need for revising the earlier view. We reiterate, and we are not withdrawing the earlier circular. Well, therefore, my lord, the board itself having taken the view, and the tribunal has elaborately dealt with the binding nature of the circular. I will not trouble your lordship. It's all well settled principle. And so, on these submissions, my lord, I beseech upon your lordship to not to disturb the order of the tribunal. But so far as royalty is concerned, the facts are like this. There is a parent company which has registered a logo. The logo is in the form of a man with the full suit, pointing his finger like this, like a cricket umpire declaring out. So it is like that. That is the logo which the parent company has registered. And the assessee company entered into an agreement with the parent company, which is called the royalty agreement, for the use of the logo for a duration which could be terminated by either party by giving 30 days notice. But there are other similar royalty agreements entered into by the group companies with the parent companies. They are slightly different in the sense that there was one agreement which was before the Madras High Court, the division bench of the Madras High Court, in that case, where the royalty payment was disallowed on the ground that it is capital in nature. In that agreement, the duration was for 5 years. Even then, I have placed the judgment before your lordship at page 81, page 81. Paragraph 60 onwards of this judgment. It's a long judgment dealing with several other issues. But paragraph 7.1. Paragraph 7.1 of this judgment of the division bench of the Madras High Court is quite a recent judgment.
Starts at
Page 140, at page 140, paragraph 7.1. Starts at the bottom.
Yes.
May I read? The assessee companies claimed royalty paid to the holding company, Mr. Sriram Chits and Investments Private Limited, as revenue expenses. The assessing officer disallowed the royalty amount and allowed depreciation at 25% by holding that the expenditure incurred is for acquiring intangible asset and would thus amount to capital expense. However, the CET appeals directed the assessing officer to allow the royalty payment in full as revenue expenditure, which was also affirmed by the tribunal. Feeling aggrieved, the revenue preferred appeals, namely so and so, whereas in the case of Shriram Transport Finance Company relating to assessment year so and so, the assessee claimed royalty amount of so much paid to Shriram Ownership Trust, which was disallowed after allowing depreciation of 25% by the AO. The said order of the assessing officer was put to challenge before the commissioner by filing an appeal in which both the grounds relating to disallowance of royalty and depreciation on royalty disallowed in the earlier assessment years 2008-9 to 2013-14 were raised by the assessee. Though the CET appeals decided the royalty issue in favor of the assessee, he directed the assessing officer to withdraw the depreciation granted at 25% on royalty payment quite rightly. The said finding of the CET appeals was also confirmed by the tribunal. Therefore, the assessee is before this court by filing so and so, raising a substantial question of law, whether the tribunal was right in not directing the assessing officer to allow depreciation on the royalty amounts disallowed in the earlier years without prejudice to the ground raised in the earlier years that royalty amount is allowable as revenue expenditure. Then your lordships may skip all those submissions. Then the finding is at page 147. 7. Paragraph 7.7. Till then it's only the submissions. 7.7. It is an admitted fact that the assessee companies had entered into a license agreement with the parent company, namely Shriram Chits and Investments Private Limited, for use of its logo on payment of royalty based on turnover, and the same is renewable. As already stated, it is a claim of the assessee companies that the license agreement confers the right to use the logo with restrictions, namely non-transferable and non-exclusive. There is no acquisition and there is only the right to use and not ownership. The same facts are here. Here at least the duration is terminable. It can be terminated by 30 days notice on either side. And therefore, the royalty payment, which is revenue in nature, falls within the general provisions of 37(1) and not under section 32(1)(2). I said depreciation is not allowable, but the expenditure is allowable in full. And then after para 7.8 is a celebrated decision of the Supreme Court in Siba, which the court has referred to and extracted the relevant passage. 7.9 is the Supreme Court judgment in Wavin, India, which follows Siba. But I will not trouble your lordship now. 7.10 is where the High Court refers to the Honda CL, which my learned friend has referred. Furthermore, in the judgment of the Supreme Court in Honda CL Cars versus CAT, it was held that while deciding whether royalty payment for technical know-how is capital or revenue expenditure, the enduring benefit test has to be applied, and the conditions to be satisfied for treating the expenditure and technical collaboration as capital in nature are: 1. There is no existing business, and 2. Agreement is crucial for setting up a new manufacturing plant. In my case, the business is already in existence. I started entering into this agreement and paying royalty only from 1/4/1998. My business was already in existence. The relevant passage of the said judgment of the Supreme Court is usefully extracted below. I will not trouble your lordships. Para 7.11. Thus, it is crystal clear from the aforesaid decisions of the Honorable Supreme Court that royalty payment made by the assessee for use of the logo or trademark for a particular period for improvement or expansion of business would qualify as revenue expenditure. The judgment in Honda CL Cars is of no assistance to the revenue, as in that case the technical know-how was shared pursuant to a technical collaboration agreement, and not only technical information was transferred, but on-field complete assistance was given pursuant to the joint venture agreement. Further, in that case, the very same business was set up by the transferee company. The assessee company was fully assisted by the other company in setting up the plant itself. So it was not merely for use of any information in the technical collaboration agreement, but it was also for other capital purposes. Further, in that case, the very same, however, in the present case, it is not the case. The grant of license to use the intellectual property of the parent company for limited purpose cannot be treated as transfer of ownership or title. Though the license is renewed periodically, that by itself does not guarantee the renewal. Similarly, the parent company is always at liberty to not only cancel the license, but also grant such rights to any other organization, because it is non-exclusive and non-transferable. Further, the findings of the Apex Court in the above judgment that when the intellectual property right is not transferred but permitted to be utilized for a particular period would have to be treated as revenue expenditure on application of the facts of this case tilts the balance in favor of the assessee. Every expenditure incurred to acquire some right over an intangible asset cannot be ipso facto termed as capital expenditure. The nature of the assets, right, information or technical know-how that is transferred must be such that without which the transferee could never commence business. As rightly contended by the learned senior counsel appearing for the assessees, the benefit granted by the licensor is not enduring in nature in the present case. The assessing officer, without appreciating the terms of the license agreement and ascertaining the nature of the expenditure incurred by the assessee companies, disallowed the deduction of royalty payment and allowed depreciation at 25%, treating it as capital expenditure. However, the appellate authorities, while deleting the disallowance made by the assessing officer, have rightly treated the royalty payment as revenue. Once the payment of royalty is treated as revenue expenditure, automatically it goes without saying that the assessee would be entitled to 100% deduction. Therefore, we need not interfere with the orders passed by the appellate authorities. Accordingly, the substantial question of law relating to royalty are answered in favor of the assessees. Lord, in my case, I will just take your lordships very briefly through the royalty agreement. It is at the index typeset number 2. What is marked as index typeset number 2? It is at page 152. Page 1, Lordships, I got. License agreement. The agreement is made in Madras this first day of April 1998 between Shriram Chits and Investments Private Limited, hereinafter called the licensor, and Shriram Chits Limited Hyderabad, hereinafter called the licensee. Whereas the licensor is the absolute owner and all that. The next page, the second para, I will read from the top only. Whereas the licensee has been using the logo without paying any royalty in the initial stages, whereas when the licensor insisted on payment of charges for use of the logo, the licensee agreed to pay royalty with effect from 1/4/1998 on such terms to be mutually agreed to. Whereas the licensee is considering it expedient, desirable, and in the interests of his business to obtain the right of continuous use of the property covered by the said copyright, approached the licensor to grant such a right by way of license on payment of consideration with effect from 1/4/98. And whereas, after mutual discussion between the licensor and licensee, licensor agreed to grant to the licensee a non-exclusive right of user of the property covered by the said copyright, being the artistic work Shriram Chits logo, subject to the following terms and conditions. Now, this agreement witnesseth, in consideration of the premises stated here and above, and in consideration of the licensee agreeing to pay the licensor royalty at a percentage of the auction turnover as provided hereunder, the licensor hereby grants to the licensee a non-exclusive right of user by way of license all the property covered by the said copyright, inclusive of the said logo Shriram Chits, and to reproduce the said work in any material form, to publish the said work, to make any adaptation of the said work in connection with the licensee's business activities in the territory of the state of Andhra Pradesh during the term of the aid of the said copyright. Duration. This agreement shall remain in force subject to clause 6 hereunder provided, without limitation as to time, until its termination by either party to this agreement by giving to the other party 30 days notice in writing, and this agreement shall stand terminated on the expiration of 30 days from the date of receipt of such notice. There is not even a fixed period here. So it's very precarious, and at any time it could be terminated by the licensor. The other things are the usual covenants, how to use it and all that. Nothing really turns on that. There is an arbitration clause, foreclosure clause. It's a very brief agreement. But this agreement, in my respectful submission, does not confer any enduring benefit to the assessee. Assessee is already in business, and from 1/4/1998, it started paying royalty for this only with a view to expansion. People know in the entire area, south of the southern part of this country, people know Shriram Chits only by the logo. And the use of the logo is beneficial to the assessee, and it is not necessary that I should demonstrate with infallible proof that it has been beneficial to me. Expenditure laid out wholly and exclusively for the purpose of the business, with the view to improving the business. Whether it is successful or not successful is not the criterion. But here, the assessee has paid royalty on turnover basis, percentage on turnover basis. And I respectfully submit that the judgment of the Madras High Court, the group company's case, may also be considered by your lordships while taking a view on that. But this is so far as royalty is concerned. But the other point, my learned friend did not make any submissions on the commission on cancelled chits. Well, should I address your lordship on that? Or?
You may make your submission.
Yes.
In reply, you may say.
Briefly, I will take your lordship. The only question.
But we'll rise at 3:30 today, huh? Because we have some other issues. We'll continue till 3:30. Then we'll have it the next hearing.
Well, I will conclude. I will conclude before 3:30. That's the only short. It's only a timing issue. I am not saying that the commission on cancel the chits is not my income. The only thing is earlier what I was doing, the moment there was a default and I removed a default by a non-priced subscriber and I removed him from the chit, I took credit for the commission because whatever amount he has paid to me, I have to return. While returning, the foreman deducts a commission for his services and the administrative expenses. That has been the practice right from, and that is shown as income at the time when he is removed. Now, the Chit Funds Act contains provisions that a removed subscriber can go to the registrar on appeal and the registrar could restore him. Our experience has been, that is the reason for the change. The experience has been that several cases, the removal was reversed by the registrar and he was restored. By the time the assessee had already shown this as income. And there is no provision in the act to exclude that income. So, because of that experience, the assessee changed the system of showing this commission income when the entire chit comes to an end and all the monies are returned to the subscriber at that time, or when the suspension, the removal becomes final, if the registrar affirms the removal, at that time, whatever monies are returned to him, the commission is deducted at that time, what they say is at the time of final settlement. So, this is a bona fide change. The assessee took the stand that that commission income accrues only when the removal has become final and accounts are settled. So, that is a view the tribunal says that it's only a timing issue, and the relevant part of the tribunal's order is paragraph 6.3. No, it's a short order, a short paragraph. There the tribunal has recorded this is a bona fide method. It's only a timing issue, and this is more scientific because the provisions of the Chit Funds Act have been taken into account, and this conforms to the provisions of the Chit Funds Act. What happens if somebody is restored by the registrar? Then there will be difficulty. So, the assessee has actually conformed to the provisions of the Chit Funds Act, and that is how the method of accounting has been approved. The taxability is not in question, only the year. So, this is the basis of.
Mr. We'll hear you on next Wednesday in reply. Because today we have some work. Ask your, you be present on the next day.
Yes.
While dictating the order, you please take us to the relevant court.
Yes, he will be present.
We'll dictate the order in the court itself, but you just help us in.
Certainly.
Because there are, how many appeals are left now? 3.
Four appeals. Right.
No, 2 gone, 13, 14 gone, 15, 16, 17, 3 are there.
2000.
3 are
Three
there.
appeals, but
3 are left. 3 are left.
but there is one appeal of the SSE, page. Next page.
Yes. The assessee's appeal, if that point is already.
ITTA
That's gone.
326.
SSC's appeal gone, Mr.
No, it's been listed, but it is listed today.
Where is it?
One appeal is listed. One appeal.
ITTA 326 of 2006.
The issue is the same. Your lordship may follow the same.
Which is right? Which is
Item number 62. Sorry, 63. Both, is it? 62.
Both.
62 and 63.
62.
62 is a S. Ravi on the other. I think it is 63, my lord.
Are
Mr. Maheshwar Rao Pucham.
we don't know. We don't know. We don't. Really, we don't. know.
We'll sort it out.
Sort it.
We'll sort
Yes,
it.
Lord. Next week we'll
Yes, hearing to